person have a cousin who's before this court, so go on ahead and give their attendance and they shall be heard.
Good morning. Please be seated. The first case for oral argument this morning is 573 People versus LaShawn Miller Henderson.
Good morning. May it please the court. Clea Weiss for LaShawn Miller Henderson. In the past year, the Court of Appeals has handed down two decisions in Telfair and Weinstein, which together have corrected the course of Molyneux jurisprudence in this state. I urge this court to grant Mr. Miller Henderson a new trial because of irrelevant and prejudicial evidence that was permitted by Supreme Court to be presented to the jury.
Ms. Weiss, you indicate both prongs in your brief, right? Both on relevance and prejudice.
That's correct.
And if I understand it correctly, you're arguing that with respect to relevance, one of the considerations in Telfair, and was the subject of debate between the two opinions, if you recall, was the difference between the facts of the preceding crime, in this case, and the temporal duration, that is, the change in time. None of that was argued here, correct? As I've looked at the motion papers, I've looked at the oral argument, the transcript, I don't see that time and factual distinction having been argued here. Do you agree with that?
I don't agree with that, Justice Curran. On page 63 of the appendix, in the written response, Mr. Miller Henderson's trial attorney does say these are irrelevant, specifically irrelevant as a matter of law. Does he specifically identify duration? No, but I do not think that the preservation requirement requires that level of specificity. The people proffered this evidence. He says, no, it's not relevant to any material issue here.
And I suppose you would say, well, the law is the law. It's the same standard. We're required to apply it no matter what.
That's correct. And in Telfair, the court was just applying 122 years of settled law to this set of facts. It was a gun possession case, but when we're talking about knowing possession, I think gun possession and drug possession, that element of knowing possession is quite similar. And that's why I believe that the holding in Telfair and the way that the court thought about the Molyneux evidence in that case as compared to the facts of that case is really controlling in this circumstance.
But don't the people cite in their brief a number of cases where our court in particular and others have relied on drug convictions as Molyneux evidence before? I mean, it seems to me if we go your way on this issue, we're going to have to abrogate those previous decisions where the Molyneux basis was a drug conviction very similar to here. So in a way, what I'm concerned with is, based on the preservation and what one could argue the newness of Telfair, or whatever it is, and the analysis there compared to what we've done in the past. So do you agree that if we follow your line of reasoning and adopt Telfair, that we are probably going to have to abrogate those cases that we've done exactly what's been done here in earlier cases that are cited in the people's brief?
So, Justice Curran, I would respond in two ways. One is I don't believe you to be abrogating any case because Molyneux inquiries are always fact-specific. We're looking at different priors and different cases in every one. So I don't think any case exactly is abrogated by complying with Telfair. And the reason I say that Telfair corrected the course of Molyneux jurisprudence is exactly that the Court of Appeals was really hewing closer to the Molyneux ruling from 1901, and that maybe the way that we've been drifting in our Molyneux jurisprudence has been incorrect. And I think that there's a line in Telfair that really shows that the Court of Appeals was kind of trying to steer New York State jurisprudence back towards the Molyneux rule. And it said, if the people are regularly relying on Molyneux evidence of prior gun possession to prove current knowing gun possession of different crimes, we have no doubt that the people will be able to conform their tactics to our holding today in order to avoid reversal of firearm possession convictions on appeal.
That sounds like you're suggesting that our prior cases cited in the people's brief were incorrect under Molyneux as now interpreted by the Court of Appeals. Do I have that right?
I think that's correct, and that if we are routinely using the same priors to show the element of knowing possession, whether it be of guns or drugs, I think that that's a mistake, and I think that Telfair shows that's a mistake, especially when, in this case, the circumstances are so different. In this case, the prior drug possession was not constructive possession in a house. It was drugs in a car that Mr. Miller Henderson was never seen inside of. The car was registered to him, and that was sort of the constructive possession of the drugs inside of that. But we have a very different circumstance when drugs are in a family home compared to drugs being in a car. So I think those are very different circumstances, and when you're relying on a prior incident where there were drugs in a car as evidence to show knowing possession of drugs in a family home, that is simply propensity evidence. And Telfair said that that is irrelevant as a matter of law.
Well, it's not just intent to possess, it's intent to sell. There's a distinction there, isn't there?
Well, so there were, I think, two elements of the crime that Supreme Court admitted this Molyneux evidence on. One was knowing possession, and the other, you're correct, was intent to sell. And I think that Alvino, Leonard, and Weinstein itself, those show that the, this is kind of a separate argument, that the evidence was irrelevant also as a matter of law to that element. And that's because, in this case, one, Mr. Miller Henderson did not contest that element, and there was no contesting to do. As the people said, this was a drug factory. There's paraphernalia in 3 rooms in the house. None of it was use paraphernalia. For instance, there was no crack pipe. It was all selling paraphernalia, razors, plates, digital scales. And so unlike Dean, where this court said that it still was relevant to selling because there was only, I think, in that case, some packaging materials in Dean. In this case, we really have a plethora of paraphernalia that shows there was an intent to sell, and it's not a disputed element at trial. In the people's summation, they do not use the Molyneux evidence to talk about intent to sell. The entire focus that the people use is the knowing possession. So it was admitted as to 2 elements, and I would argue that it's irrelevant as a matter of law as to both of those elements.
Ms. Weiss, on that point, following up on Justice Del Conte's question, with respect to the allegations here, there was drugs and paraphernalia found in 3 different rooms, if I understand it. The west bedroom, the living room, and the south bedroom where the defendant was located at the time. Wasn't the argument that the knowing possession element of that analysis, putting aside intent to sell, where your argument is that it has too much relevance, but going back to knowing possession, isn't the previous crime from 2017 where the drugs were found in a car registered to the defendant, but he was not in it at the time, relevant to knowing possession of at least the drugs in the west bedroom and in the living room? So that seems to add up in terms of relevancy, doesn't it?
I disagree, Your Honor, because I think the circumstances are simply too different. This is his father's home. We know the father pleaded guilty to, he was the co-defendant, we know he pleaded guilty, whereas the car is just, I just can't see any similarity between the circumstances of it being in a shared family home where other people have access and dominion over those drugs. They're just out and open. The grandmother is in the living room. His girlfriend is in the room.
All that. Thank you.
So I would just like to touch briefly on harmlessness. And I think that if this court agrees with me that it was error to admit this Molyneux evidence, it cannot be considered harmless. And that's because this evidence really, it brought the specter of gun violence into a case in which there was no guns and no violence. And it did that in 2 ways. First, Officer Lyle, who was testifying about the 2017 arrest, first he starts by testifying that the car was in an open-air drug market and there was a lot of shootings. So that's kind of setting the scene for where Mr. Miller Henderson gets arrested. And then he is towing the car after viewing the drugs in the car in plain view. And the ADA asks him, was there an incident that occurred while you were planning to tow the car? To which Officer Lyle testifies, yeah, we heard shots fired nearby and Mr. Miller Henderson came running up to us and told us they were shooting down the street. He also, Officer Lyle testifies that he was familiar with the Audi vehicle that was Mr. Miller Henderson's, showing that there was police familiarity with Mr. Miller Henderson even prior to his 2017 arrest. So you've got this evidence that's just bringing in gun violence, shootings, Mr. Miller Henderson's possible involvement in a shooting that he was reporting to the police. And that is incredibly prejudicial, especially in such a simple case. It's just about drugs in a family home. So I think, there's a huge problem with shootings in Monroe County and Rochester. Jurors and people are afraid of guns, and bringing in that kind of evidence, open-air drug markets, shootings, and connecting Mr. Miller Henderson to that environment is extremely prejudicial in the minds of the jurors. And that's why this evidence particularly cannot be considered harmless in this case.
When we get to that point, though, we're looking at a discretion standard, correct? And the relevance and the harmlessness will be under an abuse of discretion standard.
Harmless error wouldn't be under abuse of discretion. That would just be this court's appellate standard. But those similar considerations, you're right, are as to weighing relevance against prejudice, that being an abuse of discretion standard.
Thank you.
If this court did not reverse on the Molyneux point and did not grant Mr. Miller Henderson a new trial, I would like to address the sentencing point. I submit to this court that an unwarranted increase from a plea offer to a trial penalty is an appropriate factor to consider under this court's review power in CPL 470-15, subsection 6B. And this was a sentence that was quadruple that which was in the plea. And that's an unwarranted disparity, going from 2 to 8 years. It's unwarranted because there's no new facts learned during this trial. It's a very simple drug possession case. No new facts are learned. There's no obstruction of justice that happens in trial. No victims were harmed by having to testify at this trial. He didn't put anybody through anything by choosing to exercise his right to go to trial. Really, the only difference here is Mr. Miller Henderson exercising his right to have a trial. And in fact, he's less culpable at the time of sentencing than he was at the time of a plea bargain because he's acquitted on 2 counts, including the largest amount of crack cocaine, whereas the plea was anticipated to be in satisfaction of the entire indictment. So you've got an unwarranted disparity between the plea offer and the trial, and I'd like to focus on the co-defendant disparity too. The father in this case is more culpable, and that's a fact we know for 2 reasons. The father was offered a plea bargain, which he took, which was 4 years. His son, my client, was offered a plea bargain that was 2 years. So the people viewed the father as more culpable and offered the son a more lenient plea deal. The father also pleaded guilty to possessing the largest amount of cocaine in the west bedroom, which was the count that Mr. Miller Henderson was acquitted of. And I think the father's also more culpable because he's exposing his whole family, including an 11-year-old child, to drugs in the house. So you've got a son who is less culpable than his father, and yet he's gotten a sentence that's twice as long as his father, and a sentence that's quadruple what he was offered on the plea deal.
I think we have that.
So I'm asking this court to impose a 4-year sentence. The people in their closing repeated that this was a family business. Mr. Miller Henderson and his father were involved in this family business. So if that's what's going on, they should be, and they're convicted together, they should be sentenced to the same thing. Or Mr. Miller Henderson should be cut a break compared to his father, because he's the less culpable party in this. And lastly, if this court didn't modify the sentence, we are also asking that the sentence be vacated and the case remitted to a new trial judge with a new assigned attorney because of ineffective assistance of counsel when his attorney failed to raise and preserve a trial penalty argument under the Due Process Clause. If there's no questions, I'd rest. Thank you.
Very much. Mr. Ash?
Good morning, Your Honors. Ryan Ash for the people. If you have any specific questions, please let me know, but Justice Kern, your point at the end there about the Molyneux evidence, I think was rightly on point. And the theory here was essentially joint possession explains everything, and that the father possessed the drugs and the defendant here had an innocent explanation. And that is similar to the underlying, the Molyneux case that was introduced with the car, where it was essentially the same defense, or I shouldn't say defense, we don't know what that defense was, but same circumstances that would lead to innocence. It's like, I don't know where those drugs came from, those aren't mine, I didn't know they were there. And the relevancy of that being introduced at this trial is essentially, in order to acquit him, you'd have to find the same circumstances. That he didn't know the drugs were there, he was there by happenstance.
The defense may have a fair point about there being too much evidence of intent to sell to really make
That is
this
an interesting...
But putting that aside, the court also said knowing possession in terms of its curative instruction. And I didn't mean to cut you off, you
No.
can finish your thought. But adding it into, so that's a fair point on their side, intent to sell. But on knowing possession, especially when the argument by the people at trial, some of which won, some of which didn't, so to
Right.
speak, was that there was knowing possession of the drugs outside of the room where the defendant was located, but in the same residence.
Right.
In the west bedroom and the living room. And there you have a vehicle that the defendant was not in, but was registered. So that was the knowing possession. What do you think, is that a proper basis for Molyneux, and was that argued?
I don't know specifically about whether it was argued at the lower court. I would obviously defer to the record, but I think it is it's a proper basis for Molyneux because we have situations here where the defendant is repeatedly using it's the same circumstances. I agree, the car was his, but he wasn't there, and he was still held liable for possessing the drugs. Here, it's just, yes.
I apologize. Isn't the point, though, that, well, it goes to knowledge of possession. Now, all you're telling the jury really is that, an individual can be in possession of something that's not in the room where they are. I mean, isn't that that's obvious? That's common knowledge. That's part of the overall charge. So why is that so relevant that we talk about this 2017 incident if that's the only basis?
Right. I think it's also important to remember that the drug factory presumption wasn't charged here. And I would maybe argue that this isn't necessarily considered a drug factory case then, but in this circumstance, we're relying on accomplice liability, we're relying on constructive possession. And I agree that that's part of the legal instructions that the jury would get, but this is still evidence that he constructively possessed something rather than actual possession.
Well, but it has to go towards some issue.
Right.
I mean, and the other thing, we have this charge, this curative charge, which is supposed to remedy the prejudice, right?
Right.
We're going to give a curative charge to remedy the prejudice. Intent's not in the case. Nobody's disputing the fact that whoever's drugs they were, there was intent to sell. There's baggies, there's scales, there's all the stuff all over the place. Nobody's disputing that. But yet in curing it, apparently to cure the prejudice, you're telling the jury, ladies and gentlemen, this goes to intent. Isn't that more confusing? Doesn't that make it actually more difficult for the jury? How did the curative charge help? Let me ask.
Okay, the curative charge, I'm not aware if, and this is just maybe, I don't remember from the record exactly, but I'm not aware that the curative charge focused solely on an intent. Is that?
No, it didn't. It was knowledge. It says, ladies and gentlemen, this doesn't go to propensity. It goes to knowledgeable possession and intent.
And
it was that charge over and over again.
Why mention intent? Is that kind of the?
Why mention intent? What does it mean? What does that mean? What are we trying to tell the jury? And is it only, ladies and gentlemen, a person can possess drugs in a room where they aren't currently sleeping? Is that all we're doing?
I think, in a way, yeah, the evidence needs to come from somewhere. There needs to be some sort of link between the defendant and the other room. And for here, his defense is essentially, this isn't my apartment. And so to allow the defense to bring in that, but yet for us not to be able to say, this is how he has possessed drugs in the past.
Because there were drugs in a car that he ultimately pled guilty to 2 years earlier? That somehow helps?
Well, the element of knowing possession here, I agree it might be differently if it was evidence of actual possession previously, but both cases were evidence of constructive possession.
Okay.
Thank you. Do you have anything further?
Thank you. No, if there's no further questions, I'll rest on my brief. Thank you.
I-75, People versus Hufnagel. You just saw Mr. King. Where did it go? Okay, go ahead. Oh, no. Do we have Mr. King?
There he is.
There he is. Go ahead, Mr. King.
Good morning. May it please the court. Brad Keem, and I represent William Hufnagel. We assert that Mr. Hufnagel was denied meaningful representation. After a 7:30 examination, doctors determined Mr. Hufnagel was competent. Despite such a finding, defense counsel, in his unique way, repeatedly complained of Mr. Hufnagel's mental acuity. The trial court suggested several avenues he could pursue, including requesting an additional 7:30. Defense counsel's response, however, failed to afford Mr. Hufnagel meaningful representation. He claimed that because he was assigned, he didn't have money to speak to a psychiatrist. Obviously, that's patently false. The trial court corrected him 3 times. Defense counsel's response again was extremely concerning. He said he'd never challenged a 7:30 exam and said that maybe that's something they do in Syracuse. The idea that there's a different standard in Syracuse and Oswego is obviously concerning. If you truly believe that Hufnagel suffered a mental health event or issue, his willful ignorance cannot be accepted as meaningful representation. Later, defense counsel did not adequately protect Mr. Hufnagel during his waiver of jury trial when he just repeatedly said, yeah, I guess so. That's equivocal, we'd argue. And I think that goes to cumulative ineffectiveness. And then finally at sentencing, there was no reason to just jump to sentencing. Mr. Hufnagel was overcome with an emotion. He could not meaningfully exercise his right to speak at sentencing. An adjournment of sentencing would also have allowed defense counsel to investigate exactly what was going on with Mr. Hufnagel's mental health or intelligence issues that could have allowed the trial court to more fairly and understandably sentence Mr. Hufnagel.
Mr.
So,
King,
yes,
Mr. King, can you hear me okay?
I can.
You've raised a number of points in your brief with respect to what you referred to as the lackadaisical attitude toward pertinent legal issues, as well as a failure to object with respect to various issues which may have displayed a lack of understanding of the law. I think that's the essence of the argument in the brief. My concern is we really don't have any evidence in this case, in this record, about the nature, extent, whatever, of the defendant's mental disability, if any. And so we're sort of looking at only one end of the equation. We don't have both. So my ultimate question is the best remedy here a 440?
I certainly think a 440 is a possibility, but I think that based on what defense counsel is saying, defense counsel said that he can barely speak, I think was one of his quotes, that he just doesn't understand the proceedings. When taken together, and the brief has a litany of these quotes by this defense counsel, that I think that is enough in and of itself for this court to find that if this is what defense counsel was finding, if this is what defense counsel's opinion was about Mr. Hufnagel, then his failure to act was less than meaningful.
Or alternatively, Counselor, the defense counsel was trying to blunt some of the other evidence, including the statement that the defendant had given to the investigator, that the 8-year-old had come on to him, and that the 8-year-old pulled on his sweatpants. I mean, this was a pervasive strategy throughout, even in the Huntley hearing.
The performance of this defense counsel if that's a strategy, I would argue it's not.
Well, remember though, he did request the initial competency examination, and the court granted the initial, and you're saying that he should have asked for a second competency examination. That's your point.
If he repeatedly said that he thought that he had mental health issues, Your Honor, and upon the trial court suggesting, well, why don't you try to do another 730 3 times, he then goes into a nonsensical diatribe about what he perceived the law to be, which was fundamentally false.
Okay, we'll look at that very carefully, Mr. King.
Thank you, Your Honor.
Okay, go ahead.
Amy Hollenbeck on behalf of the people. Your Honors, I think that it's pretty clear that defense counsel's comments don't override a presumption of competence, a finding of competence by 2 professionals, and the court's own ability to make observations of this defendant at multiple court appearances, as well as observations from the video of his statement to the police. I think it's clear from the record that he had some limitations, some learning disabilities, but his waiver of jury trial was thorough. He twice asked the court to repeat questions to ensure that he understood them. He spoke with the police officer in a competent way. And I think that Justice Del Conte's comment about defense counsel's efforts to gain some sympathy or some understanding from the court to try and blunt the effect of what he had done is perhaps the strategy that was going on here. But whatever the strategy was, his competence on the record is clear, and there's nothing to undermine that. So no matter what the defense counsel has said, it doesn't change the fact that he was competent. And I've addressed briefly the waiver, but I think the court the record is very clear that waiver was very thorough. And the court made an effort to speak to the defendant in a way that he understood, even adopting his language when she asked him about what was the difference between a jury trial and a trial by judge. And he said, I would be judged by people. the people would judge me. And she immediately adopted that. So she was really working with him to ensure that he understood and that she was satisfied that he understood. I would also point out that defense counsel, in spite of making these comments, he asked for the initial competency exam. He asked for the suppression hearing. He counseled the defendant on a waiver of a jury trial in a case that involved an 8-year-old victim who was 10 years old when she was testifying. He did a thorough and complete cross-examination of that 10-year-old that was very appropriate for dealing with a 10-year-old, and brought out any inconsistencies that were present. The inconsistencies that he brought out were not significant, but he did his very best to work with what he had. And all of this in light of the fact that the defendant had essentially confessed his involvement in this, although attempting to kind of place blame on the 8-year-old victim. So altogether, I would say his representation was competent and was designed to assist his client in the best way he could under the circumstances he had to work with. Thank you.
Thank you. 576, People versus Chase Walker. Okay, Mr. Punch. Can you hear me?
Yes, I can hear you, Your Honor. Thank you.
Great.
Your Honor, first I would like to address the case of People versus Johnson and what its holding meant as applied to this case. I believe it held that the only impeachment material that is required to be automatically disclosed pursuant to that statute is that which is actually related to the subject matter of the case. That was stated in the decision, and then the decision cites only People versus Lewis, a lower court decision when it was holding that no such personnel records were present in that case that were subject to automatic discovery. And Lewis made clear that the use of related to the subject matter in the first paragraph of 24520 sub 1, it qualifies every preceding paragraph in that, including section K. In this case, the materials at issue did not relate to the subject matter of the case.
Mr. Punch, would you agree that the district attorney's office has a duty under the discovery statute to at least make diligent efforts to obtain whatever disciplinary records may exist for the parole officer in this case?
Yes, Your Honor, I would agree with that.
Okay. And that by the certificate of compliance says they did, says that they did do the diligent efforts, each one of the certificates of compliance.
Yes.
All right, well, the first one was before they even reached out to docs. So how is it an error that the first certificate of compliance was a nullity or was a void?
Well, first, Your Honor, it's true that the record that was made in support of the argument only reflects the March 10th reaching out to the docs, and that's all I can rely on this record. However, that wasn't the certificate of readiness that we relied on to stop our trial readiness clock.
Okay, hang on one second. So the March communication that you're talking about, that was after the first certificate of compliance, which was within a month of the felony complaint. But the March inquiry was before the second certificate of compliance. I'll give you that. The problem with the March inquiry that I see in the record is that the March inquiry was responded to by docs saying, can you please give us the names of the officers? And I don't see anything in the record where that was provided until after the second certificate of compliance. Is that fair?
That is what the record says, Your Honor.
Okay. Now, after the second certificate of compliance, there was a third certificate of compliance too. We'll get to that in a second. But after the second certificate of compliance, there was a request from your office or from the DA's office that said, here are the names of the officers and give us the disciplinary records. And docs promptly responded to that and said there was no disciplinary action taken against the officers or against the specific officer that we're talking about that's relevant to the case. And that's fair, right? And then that was sort of the reliance that your office had and said, well, there's nothing there then, right?
Well, yes, Your Honor.
Okay.
we made multiple requests for them. They were not as specific as they could have been, but I think,
Well, but the judge ends up dismissing the case because he found the request to be perfunctory, so we have to look at the requests, right?
yes, Your Honor, but the first, I believe, according to this court's decision in People v. Johnson, that the first decision that, the first determination that has to be made is whether these records relate to the subject matter of the case and would therefore subject us to dismissal pursuant to CPL 3030.
Well, but the thing is, even before we get to the records, if all we have are certificates of compliance that say a diligent search has been made, and we find that a diligent search has not been made, are the certificates of compliance a nullity, and then is the 3030 time just running?
No, Your Honor, that's not how I would interpret People v. Johnson, which says that, I mean, we can't be held liable for 3030 time regarding documents that are not even subject to discovery in the first place.
All right, so if they don't make a diligent search, and they say they did in the certificates of compliance, and 3 years go by, and then, you know, at the very end of the day, 3 years right before trial, we find these documents, and if it turns out that the documents that were never searched for all along, that they're not really relevant, you say, well, no harm, no foul, and that's it. And that's your reading of Johnson and the way that we should go
Well, it's
forward.
not necessarily no harm, no foul. It could still subject us to sanctions pursuant to subsection 80. But I don't think that non-discoverable, the existence or lack of existence of non-discoverable material should not subject us to dismissal of the case pursuant to People versus Bay.
Mr. Punch, is part of the point that because it's not within the possession, control, et cetera, whatever the language is, of the people at the time you file your initial certificate of compliance, there's no duty to go find it with respect to automatic discovery under subdivision 1. You might have a duty under subdivision 2, but with respect to initial discovery for the defendant under subsection 1 of 245.20, once it's not in your control, that is law enforcement, et cetera, then you don't have the obligation at the time you file your initial COC to exercise due diligence. You're representing that you've exercised due diligence vis-a-vis those materials that are subject to automatic discovery as defined, which includes that which is within your control. Does that make any sense? That was a long question, sorry.
And that was my argument that I was making to Justice Nowak, but it was much better put. But yes, that's a well put argument. My next argument is that these were unsubstantiated. They don't even have impeachment value. It would be akin to just an arrest, impeaching someone with an arrest, not a conviction, or with an acquittal. They don't even provide a good faith basis to believe that the complaint of conduct even happened. And for that reason, I don't believe that they should. I know lower court cases have been inconsistent about this, whether unsubstantiated complaints are required to be turned over, but I don't think there's any reason that they should be according to the statute.
Do you have anything further? Oh, sorry.
Just brief, Your Honor. It's also, we're deemed to be in possession of materials that are in possession of law enforcement, but
And
only
we
those
understand
related.
parole is not the.
No, parole is, but I acknowledge that parole is a law enforcement. We're deemed to be in control of their materials, but the statute says only when it's related to the prosecution of the charge. And as I argued in my papers, a complaint made not about this defendant, not about anything to do with this investigation, years before this investigation, is not actually related to the prosecution of this charge. And it's the same rationale that the Court of Appeals used with People versus Garrett. The police were not acting as an arm of the prosecution or the parole officer. These years prior complaints were made. It would be drastic to hold us to these extreme penalties for things that were not even related to the prosecution of the charge. And finally, I have a brief point. Going through the more recent cases like Sumler, This court never actually held that we did not exercise due diligence pursuant to bail. It did use the word due diligence, but it said that our efforts were perfunctory because we're not able to successfully obtain the materials. That was the only reason that the court said we lacked due diligence. Even the defense below said that the people did due diligence and we made every effort to obtain these. So I believe if the court were to find that these materials were subject to automatic discovery, the proper remedy, at least going by the last few cases, Sumler and Mitchell, et cetera, would be to remand to make a determination pursuant to Bay and not hold us to strict liability.
Mr. Punch, just on the last point that you raised, the argument that I think you made that it is a law enforcement agency, the Division of Parole, if it's related to the prosecution of the charge. So is that only if there's a disciplinary report that's related to the same incident? Is that what you're claiming?
Yes, Your Honor.
Okay, so if there's a disciplinary report a month earlier on a different person, but the facts are similar, you would say, well, no, then they're not a law enforcement agency.
No, I'm sorry. No, I misunderstood your first question. They're still a law enforcement agency, but we're only deemed to be in possession of records that relate to the prosecution of the charge.
Okay, can you give me an example of what that would be?
The example would be in this case, a parolee complained that this parole officer harassed him in 2006. That does not relate to the prosecution of this charge. That's my argument. I mean, and I understand to the extent that anything that could be considered impeachment material could arguably be deemed related to the prosecution of the charge, but I don't think that's a reasonable reading of the statute.
Because it's remote in time.
Remote in time, and it has nothing to do with the mistakes, whatever, the alleged harassment didn't occur in the, while this case was being investigated. It's remote in time, and it has nothing to do with any potential defense or anything related to this case.
Okay.
Thank you.
That's from Lewis, but the case cited.
Thank you. Thank you. Go ahead.
May it please the court, Susan Hutchison on behalf of the respondent, Chase Walker. The trial court did exactly the right thing here by dismissing the indictment. This case is layer upon layer of failures. First, as the trial court properly found, there was a failure of due diligence. As Your Honor has stated, the first email did not even ask for specific names, and that first email to docs was 10 months after the filing of the first certificate of compliance.
Ms. Hutchinson, where I'm hung up, at least for the moment, is looking at the definition of what's in the possession of the prosecution under 245.20 sub 2, which is referenced and incorporated into the description of automatic discovery under 245.20 sub 1. If this court concludes that these documents, as possessed by docs, were not in the possession, custody, or control of the whole language at the time the initial COC was filed, they were not there, you would agree there's no obligation for due diligence at that moment because they're not within their control. That's what has to be produced then, right?
Your Honor, respectfully, the statute deems the disciplinary records in the possession of the prosecution.
Understood, but let's assume that docs is not a law enforcement agency, that it's a totally separate agency. It's not a law enforcement agency. It's not the New York State Police. It's not local police. It's not anything that meets that definition. I know that's contrary to your argument, respectfully. I know that. I'm not trying to make you change your argument. But I'm trying to say, let's assume for the sake of argument, contrary to what you'd like us to conclude, that we find that these records were not in the control of the prosecution, custody, whatever, at the time the initial COC was filed. That would mean the COC is proper, correct?
No, Your Honor, because there still is a lack of due diligence, and one has to look at whether the prosecutor made any efforts to obtain those records prior to the filing of the certificate of compliance. And here, all of the first two emails were well after the first and second.
Forgive me for pinning it down here, but 245.20 subdivision 1 specifically pertains to the obligation to produce automatic discovery. And it says within that very first sentence that it has to be in the possession or control of the people. If it's not so, then it's not part of automatic discovery. And the COC, as initially filed, only pertains to automatic discovery, not that which you obtain later, a supplemental COC, but only at the time you file your initial COC. And as I read 245.50 subdivision 1, it pertains only to subdivision 1 of 245.20, automatic discovery, which therefore you can't find a certificate of compliance improper unless it pertains to automatic discovery. If it's never in the possession or control of the people, you don't get 30-30 relief. Do you agree with that interpretation of the statute?
Your Honor, respectfully, no. It's my position that because there is a deeming here of possession, that it does apply and 30-30 is applicable. And
I asked you to assume it's not in the possession. So you don't get 30-30 relief then because it's not in the possession, right?
perhaps hypothetically, Your Honor.
You may get other
That's
relief, but not 30-30.
You may get a sanction, sorry, Your Honor.
I'm sorry.
Correct, Your Honor. But in any event, here, in this case, there were multiple layers of failure on the part of the people. It's not even clear that this is a legitimate charge, frankly. The people struggle to articulate what the lawful duty was. There's issues about the injury, but leaving all of that aside, the critical issue here was the lack of due diligence, which the trial court properly found. He I think, very carefully worded as perfunctory, but I think that was being kind. And this case stretched over a period of 2.5 years.
Well, there then.
Yes.
Ms. Hutchinson, let me take it to a hypothetical. Let's assume that it's a sex abuse case for the sake of argument. And I'm going to make up a document. The victim in the sex abuse case has a diary about which the people know nothing for quite a period of time. And it's clearly not in their possession. Are you saying that by not going out to get it, that it's part of automatic discovery, or is it something they have an obligation to go get? So I'm just saying, I'm focusing on, if we assume it's not in the people's possession when they file their initial COC, like the diary, I don't see how you get 30-30 relief. Now, let's assume a month before trial, the people get it in their possession. They're preparing for trial, the witness brings it in, now the people have it in their possession. And they file a supplemental COC, I don't think that that's a violation of subdivision 1 of 245.20. So you might get a sanction, but you're not going to get dismissal on 30-30. Now, if they don't disclose it to you, we would agree that it is part of automatic discovery, so you might get dismissal on 30-30 then. Does that make any sense to you? And if not, I'm sorry to throw this long question at you, but I'm really struggling with this statute because it's so new, and I'm sorry to take it out on you. I'm really I'm looking for help.
I appreciate the hypothetical, and yes, I can see your point. And in that case, I think you look at what sanctions might possibly be imposed in that particular instance. But here, my position is the people didn't even ask the parole officer if he had a disciplinary record. There was no conversation.
I think we understand that.
Okay.
Have anything further?
I will rest on my papers. Thank you.
Thank you. 577, People versus Dondorfer.
Morning, Your Honors. Dana Poole for the People. The question presented in this case is whether the word impaired retains a consistent definition throughout the DWI statutes, or whether its definition shifts depending on what subsection of the statute we're talking about or what prohibited substance is involved. As the Court of Appeals has found, impaired has a common and well-known meaning. It simply means impaired to any extent. There is some disability caused by the substance.
In this case, it's drugs, not alcohol.
In this case, it's a combination of drugs and of a drug and alcohol.
Well, the alcohol wasn't a level to charge the tax, though, right?
That's right. I believe it was a .06 BAC. So this defendant was charged as driving impaired by a drug in
And it was
combination
a
with
felony
alcohol.
because there's a child under 15?
That is correct, Your Honor. So the statute uses this word impaired throughout
With
the...
the felony, wouldn't you think you would use a stronger level? Since it's a felony, but potential more criminal charge as far as this is concerned?
The question is that the...
Wouldn't it be proper to use the intoxication because it's a felony, because it's a more severe penalty involved in this?
Well,
versus an
in
impaired,
this
which
instance...
could be a violation?
Well, in this instance, what we have is intoxication refers to only alcohol. It does not refer to an impairment caused by a combination of a drug and alcohol or drugs alone.
And the statute's very clear that the impairment, the lesser standard of the impairment does not apply if it's just, I'm saying this incorrectly, the intoxication standard is a higher standard, correct?
That is correct.
But if you're not being charged with the intoxication, because it's not a high enough BAC, but it's a combination, you're saying the statute says then you should be using impaired.
Right. So when we're talking about when a drug is involved, whether alone or in combination, impaired is the only word used in the statute. So intoxication and its higher level of impairment applies only to alcohol. When drugs are...
I'm sorry, you can finish your thought. If you like.
When drugs are involved...
I'm following up with a question from Justice Smith.
The only question is whether the defendant has been impaired to any extent.
And People versus Litto, L-I-T-T-O, seems to make this abundantly clear, and I just pulled up the case on my computer here, and there was felonies and misdemeanors, and the court was very clear that intoxication pertains only to alcohol. Repeatedly says it in that case, rejects the argument that somehow you're going to use impaired or intoxication for drugs.
That's correct.
And so Litto is something that you say is basically directly on point, especially when you add it to Cruz from 35 years ago. That distinction between drugs and alcohol has remained consistent, and the legislature has repeatedly dealt with this statute over time and has never changed it.
That's correct, Your Honor.
Including when they legalized cannabis.
That's correct. In fact, they added cannabis into the list of prohibited drugs to ensure that it was not treated the same as alcohol. So the language of the statute is absolutely clear. The standard is simple impairment, impaired to any extent. And when you look at the legislative history, including the fact that the legislature, throughout the history of this, including in the 40-some years since Cruz was decided, has never offered an alternative definition for impairment when it comes to drugs.
What's your opinion about the Caden case then?
I think Caden N was decided incorrectly. I think what happened in that case was that the Third Department applied its own logic, and it's not illogical logic. There is a logic to saying that equal levels of impairment should be treated with equal severity, but that is simply not what the legislature chose to do. And there are plenty of good reasons that the legislature made that decision. I think that they're laid out fairly succinctly in the amicus brief. But the question here isn't what is the best policy to be followed.
It's the statutory interpretation.
That's correct, Your Honor.
Doesn't the CGI, though, then refer to Caden and use the intoxication standard?
It does, Your Honor, and that's what the court below was relying on. But interestingly, what the CJI committee did was include an explanatory note saying, we're doing this because of Caden until another appellate court says otherwise. And they indicate and they tell the trial judges, you're not actually obligated to follow this, which is a very unusual thing for the CJI to say. And in most cases, judges try to follow the CJI so that they are ensured of getting the law right.
So you're saying it was an error for the court below to follow Caden and the CJI?
It's understandable why the court did that, but it was error because that law is actually incorrect. And we are asking that this court be that other appellate court that says otherwise, and that says, in fact, the proper interpretation of this statute is that impaired means impaired whether we're talking about alcohol or whether drugs are involved to one extent or another.
Thank you.
Thank you, Your Honor.
Good morning, Your Honors. Faris Rumi appearing for defendant respondent. May it please the court. Your Honor, we would submit that the CJI states that the Caden standard is not one that the courts are required to follow, precisely because there is no binding case law on point. There is no current case decided by either this court or the Court of Appeals which clarifies how to interpret impairment under 1192-4A. As such, the CJI scholars who drafted, they looked at Caden, they found its logic compelling, and they recommended that the trial court use it. And Your Honors, our position is as follows. As the people note in their brief, the plain text of the statute is important. However, as the Gola case affirms, that's just the starting point. As Judge Wilson explains in the Roberts case, you still need to apply the 4 rules of statutory construction. And when you do so, it is our position that the only interpretation that avoids an absurd result, which would be treating a misdemeanor and felony level offense, driving liability impaired by the combination of drugs, or an alcohol or drugs.
So isn't your challenge really to the constitutionality of distinguishing between drugs and alcohol in this regard? Because the argument made in the amicus brief, at least, is there are sound policy decisions that could be ascribed to the legislature for distinguishing between the two. The one that comes to mind sitting here is that proving impairment by drugs is much more difficult than it is with respect to impairment of alcohol or intoxication for alcohol. So you can, I think your argument really is, or should be, the constitutionality of the statute, but that's not before us, and it wasn't before the court in Caden. Do you agree with that? That's really what your argument should be.
Your Honor, I would submit that the argument, that goes to the 4th rule, which is the rule of lenity. You know, as Judge Wilson explained, a person should know and understand what they're being charged with. And that's why when there's a criminal statute, one of the rules of statutory construction is if there's some ambiguity. Right now, there is no binding case law in this department over how to interpret impairment under the statute. There are 2 possible interpretations. One is adopting the Cruz standard or the Caden standard. The Caden standard is more favorable to the defendant respondent, and that is part of the policy. In the Roberts case, Judge Wilson does explain that.
Tell me, Counselor, in your brief, you make absolutely no mention and do not discuss People versus Little. And Little from 2007, written by Chief Judge Kaye, describes how intoxication is limited to alcohol, and it's not going to be intoxication pertaining to drugs. So under Cruz and Little, it seems pretty clear that they've drawn this distinction, and the legislature's never tinkered with it. So I guess my question is, if you can't distinguish or even address Little, isn't that very revealing about the strength or weakness of your argument?
I don't think so, Your Honor, and I think it's because count 1 of the indictment is aggravated DWI. And, I would submit that perhaps the legislature should consider amending the language to make it more clear. But it's aggravated DWI, but it's under the sub-theory of 1192-4A. So this case is not a purely a DWI in terms of alcohol case. It's an aggravated DWI under the theory that defendant respondent either operated the vehicle under the influence of drugs or the combined influence of drugs or drugs and alcohol with someone under the age of 15 in the car.
Well, why not address Little?
Your Honor, I felt that the case law in Roberts and in Caden was clear. And so when I drafted my brief, I felt that that was clear in addition to exploring the rules of statutory construction.
We'll look at that all very carefully. Obviously, there's a lot we have to mull over here.
Okay.
Thank you.
Thank you, Honors.
579, the matter of Aspen Liddell versus Bryant Jones. I'm sorry, Ms. Walton, I didn't see you up there. Go ahead.
Good morning, Your Honors. May it please the court. Kara Waldman, representing the mother. I was assigned to this appeal after it was perfected, so I bring a new perspective that I would like to briefly express to the court. Whether this case is analyzed under tropia or as a modification, I think the outcome is still the same. Mom should have been given primary placement for school purposes. I want to briefly address family court's 4 reasons for awarding the father primary placement. First, I want to note that the mother did not choose to relocate to Bath, but was the victim of an unfortunate house fire that left her homeless. She needed to find appropriate housing for the children under those circumstances and decided to move in with her then boyfriend, father of her other child, who is now her husband. Second, Hunter was not receiving any services at Marcus Whitman unique to that school district, like speech therapy. He was receiving extra support for reading and math. He had no
Ms. Baldwin, if I could just interrupt on that point, because I don't want to have to backtrack. With respect to the Marcus Whitman School, the record reflected that he then improved in engaging the services that that school provided, right?
Correct. But
Okay.
there was no evidence that those services would not be given to him at the Bath School District.
Sure. In fact, your client mentioned that the school district in Bath had some suggestions or ideas about what to do to work on Hunter's weakness areas. I think that's a quote directly from the record, from her testimony. But that's it, right? That's all we have is that one quote from the testimony. We don't have anything from a teacher. We don't have any documentation, nothing.
Correct. But again, the child does not have an IEP or a 504 from Marcus Whitman. He wasn't receiving speech therapy. These were merely extra services in reading and math. And the mother was the parent who initially tried to get him into counseling, and the father didn't agree at first. The third reason, the father testified that he had started a new position at Casella, but he couldn't give specifics or any proof. He said that he would have more flexibility with this job to put the kids on the bus in the morning. All of this testimony was pure speculation and should be disregarded. Fourth, the father failed to present any contrary evidence that he gets angry and aggressive towards the mother. In fact, his girlfriend admitted that he gets triggered by the mother. I understand the AFC's position that the children want to stay at Marcus Whitman with their friends. They don't know any differently, but as the panel is aware, you have to consider what is in their best interest. These are young children who are resilient. Awarding the mother primary placement allows the children to live with their half-sibling during the school week, strengthening the bond between the siblings. And there are ways that they can see their friends at Marcus Whitman, such as play dates. Considering all the facts of this case, it is in the best interest of the children to award the mother primary placement for school purposes, and she asked the court to do so. Thank you.
Thank you.
Good morning. May it please the court, Megan O'Leary for the respondent. Your Honors, I agree with opposing counsel that the decision would be the same if it were a modification or evaluated under tropia. However, I disagree with what that outcome would be. I ask that this court affirm the lower court's decision. There's a sound and substantial basis in the record. Hunter has improved in the topic stated. They've gone to the school their entire lives. They're actually starting 5th and 2nd grade today. They, get on the bus with their cousins. They have substantial time with both parents, and the parents originally agreed to the children remaining in the Marcus Whitman district when they consented to the 2019 order. The only issue was being able to get the children to school on time, which this order has been able to correct. If there are no questions, I would rest on my papers.
Thank you.
Thank you.
May it please the court, Tyson Blue, attorney for the children. As stated in my papers, my clients have been consistent so long as, in Hope's case, they've been able to communicate that they do want to stay primarily with their father and continue to attend school at Marcus Whitman. They like their friends there. They have a couple of cousins as well. And I would note that yes, Hunter did receive reading and math help and had shown improvement in those areas, especially with reading. He didn't even like to read, but has come to enjoy it very much, which is going to help him in the long run. I believe that allowing them to remain primarily with their father would be the least disruptive disposition, as they wouldn't have to change their primary place of living and to change school districts, and would ask that the court affirm the decision of the lower court. If there are no questions, I'll now rest on my brief. Thank you.
582 through 583 in the matter of Blossom.
Good morning, Your Honors. May it please the Court. Joseph Beatar, Mental Hygiene Legal Service of counsel to Elizabeth Fortino, here on behalf of Appellant. As the Court is aware, these two consolidated appeals are taken from two separate lower court orders. The first, a granting of respondent's petition.
We're well aware, but can you tell us why these would not be moot?
Sure, Your Honor, and I could go through both appeal number 1 and appeal number 2. So as the Court is aware, the three-pronged test for mootness is likelihood of repetition, either between the parties or members of the public, an issue that typically evades appellate review, and third, whether the issues are substantial and novel. So starting with appeal number 1, which is the Rivers petition in question.
Would you be able to do appeal number 2 first?
Sure, Your Honor.
That's a better idea.
Thank you. So regarding appeal number 2, likelihood of repetition, by the very nature of that court's order, it calls that all future Article 9 hearings be conducted virtually as being exceptional circumstances under the Robert F. standard. So by that very nature, we're looking at a likelihood of repetition, indicating that all of those future cases will be held virtual. And we already see the repetition occurring. The court at the lower level consolidated 6 separate cases into one oral argument. So all of these matters were converted into virtual proceedings. With respect to prong number 2, an issue evading appellate review, by the time an appeal can generally be reviewed, the in-person or virtual motion has already been decided, which leaves us at a point of having a court, giving the court the ability, lower court the ability to insulate itself from review, which may be a slippery slope when these issues are continuing to come up, not only in the 5th Judicial Department, but the 7th Judicial Department, as well as Erie County as well. And substantial and novel, Your Honors. First, again,
It's not substantial and novel anymore.
Well, at the appellate level, respectfully, I would say it would be still substantial and novel, because this issue has not been decided by an appellate court, insofar as the lower court's order in appeal number 2, again, applies its decision to all Article 9 potential litigants who, and again, I just want to add, these issues decided by the lower court decide potential issues of fact that are non-justiciable, applying them to Article 9 patients who are not yet hospitalized, who not yet have a pending petition. So for those reasons, we would argue that appeal number 2 is certainly an exception to the mootness doctrine, as conceded in the record by the lower court and conceded by respondent. Now, delving in more to the Robert F. standard, exceptional circumstances, it's a test of necessity. Are these virtual proceedings necessary? How do we show they're necessary? By demonstrating exceptional circumstances. It's respectfully submitted that the lower court did not go through the case-specific exceptional circumstances test as outlined in People v. Rotten, as outlined in State v. Robert F., and also outlined by this court in People v. Tosley, which also noted the burden of proof is that of is that of clear and convincing evidence. So the case-specific aspect, again, we're looking at a lower court ruling that consolidated 6 separate appeals. Appellant submits that in and of itself shows that there was no case-specific analysis done. It was a general principles that were set forth by the lower court and respondent insofar as the reasons why virtual proceedings carry the day over in-person proceedings, whether it be cost. Yes, Your Honor.
You would agree that a court, any court, would have the ability, if one party, a hospital, were to say, gee, could my witness, my doctor, appear remotely today, that the court could grant that over an objection by opposing counsel at any time, really and frankly in any case, and not only in Article 9s, right?
I think where the exceptional circumstances test is conducted, and I believe, Your Honor, that comes from Judiciary Law 2-B, subsection 3.
Exactly.
So in People v. Rotten, the court identifies that the court has that inherent authority, but also states that it's an exceptional procedure to be used in exceptional circumstances. And that's where we start to look into, well, what are those exceptional circumstances? Is it necessary for a witness to testify remotely? And that's where we really see the test played out in those cases.
Well, I thought your position wasn't so much requiring a doctor to come to a courtroom. I thought your argument was really preserving the right of an individual petitioner, somebody that is the subject of the Article 9 proceeding, that they have an opportunity to be in court if they feel that they would be best represented there, meeting with counsel, et cetera. I thought that was the basis of this, is to make sure we preserve that right, not to make sure that doctors travel to courtrooms.
So really it is a twofold argument, as Your Honor noted, to protect the patient's right to appear in court in person, but also, and Rotten did mention this as well, People v. Rotten in the Court of Appeals stated that virtual testimony is certainly no substitute for an in-person appearance. And keeping that in mind, that's where these cases start to develop of, if a party is requesting virtual testimony, they can do so. If there's an objection, that's when the cases indicate that the court conduct that case-specific test of necessity by having the proponent of the virtual testimony, in this case St. Joseph's, come forth with, by clear and convincing evidence demonstrating what those exceptional circumstances are, if they meet that threshold to warrant virtual testimony.
Counselor, I have found at least 3 or 4, in fact, recent cases where we've held that in this situation, it does not fall within the exception of the mootness doctrine. I don't think there's any question that both these appeals are moot. The only question is whether or not you fall within the exception. And I mean, I don't know if either side cited those, but there's 3 or 4. You know, we follow our own precedent until there's good cause not to, I suppose. But I mean, are you familiar with those cases? One is Bryant is one case, and Bosco is another from a few years ago, McGrath. There's a good series of 3 to 5 cases from our court that say this does not fit the exception. So I'm not sure you've presented the argument, because you haven't cited those cases, that we should no longer follow them, and you haven't even distinguished them. So aren't we sort of stuck as a court based on precedent to simply follow that?
Well, I would say certainly respect to appeal number 1. Appeal number 1 is distinguishable from the cases Your Honor just noted. Here we have a Rivers petition that was granted for temporary relief in lieu of the merits. Those are the court's words on page 76 and 147 of the record. So there's an issue here certainly of
Forgive me, are you saying that one's moot and one's not? Or you're agreeing that they're both moot and only one is subject to the exception?
Both.
Maybe neither.
Both. Our argument is both fall within the exception to the mootness doctrine. And I can see the court's perspective specifically with the Rivers aspect. This court has ruled numerous times that prior Rivers orders do not fall within the exception to the mootness doctrine. But again, the difference here is this order, this petition rather, was granted on a temporary basis, quote, in lieu of the merits, which we haven't seen. And if a court is able to insulate itself by simply saying this is granted on a temporary basis, I think that's a slippery slope for consideration for this court.
I think we have your argument. Thank you.
Thank you. For all remaining points, we rest on the brief. Thank you.
Your Honors, Robert Connolly on behalf of the respondent. First, I want to address a few of the points that were made by counsel. I don't interpret the lower court's decision in order to state that all future applications are subject to my order. I think that more dicta when he suggested that it likely that mental hygiene Article 9 cases fall within this and you should probably apply in this manner with an application. His holding was that exceptional circumstances existed. And that was based upon a 10-page decision that outlined, both from oral argument as well as the papers, the detail within which he was relying to find those exceptional circumstances, whether it be the safety issues, whether it be the travel, whether it be the appearance by the parties, or whether they did or did not appear after they requested it. Those circumstances were what the judge relied upon in making the determination that this, as with others, satisfy the exceptional circumstances. I also dispute the reach of the order. This decision essentially said and found we have exceptional circumstances, Robert F. applies, and I have, the judge, I have the authority under Judiciary Law 2B and other constitutional provisions to set policies and procedures in my courtroom as to how I receive evidence from a witness, including remotely. And he did so. And so the review of this court's decision, I believe, is a simple one. Now, getting into the weeds and talking about Robert F. and Roten before it, certainly there are arguments to be made as to whether those cases reach us, whether as counsel tried to explain, it was reaching all virtual appearances versus were they talking about what they actually were talking about, which is closed circuit television in 2009, which is so vastly different now as we see right in front of us. The technology has made assurances of the evidence that's being presented, that it is now reliable to the point that full trials, full hearings are being conducted remotely at great savings to the state and at benefit to both parties. Now, the prejudice that we're concerned about in the confrontation clause is that it be reliable and that there be an opportunity. Certainly those still exist and Robert F. is still good law, but the reach to which it gets to us in a different environment and in a different era would be tantamount to saying the 15 mile an hour on a horse and buggy still applies, but we're not driving horse and buggies anymore.
Okay, I think we have that.
Okay. And with regard to the mootness doctrine, while I believe, an argument can be made that an exception to the mootness doctrine stands, the exceptional circumstances, I believe, rule the day with regard to that, so.
Thank you.
Any questions? Thank you.
584, Jackie Mylar versus Niagara Falls Memorial Medical Center. Oh, I'm sorry. Ms. Nowak is recused on this matter.
Good morning. May it please the court, Melissa Zittel on behalf of Dr. Cormier and FTR Medical Services. The defendants' appellants. The appellants have shifted the burden on both liability and causation, submitted an affidavit or an affirmation, by an emergency medicine expert, Dr. Asher, on liability, and then submitted a separate affirmation of a pediatric ophthalmologist on the issue of causation, the affirmation of Dr. Markowitz. In response, the plaintiff only submitted an affirmation by an emergency medicine physician. That cannot and does not properly rebut the defendant's motion.
Ms. Zittle?
Yes,
As I
Your
read
Honor.
your brief, your primary point is that the element of causation is missing here, correct?
That's correct, Your Honor.
And specifically that there were unforeseeable events that occurred after January 16, 2012 that broke the chain of causation. Is that your argument?
That is, yes,
Primary
that's,
point is what I phrased it. I realize you have other arguments, including the duty not extending, et cetera, but in terms of the primary argument you have, that's causation and foreseeability and intervening cause.
is foreseeability, intervening cause, and also that the emergency medicine expert has no foundation, either by qualifications or any basis in the record, for the opinions rendered that the actions by Dr. Cormier caused the Miss Mason's injuries, sorry.
And forgive me, I wasn't trying to have you waive your other arguments in your brief, but the way I read your brief, was it fair to say the primary point is causation and foreseeability? Did you say that this is one of those unique cases where we can determine it as a matter of law?
Yes, Your Honor, and also, according to basically a string cite of precedents that where this court has held, that summary judgment motions can be decided on the issue of causation, and that if there's a failure to rebut the issue of causation, the defendant's motion should be granted. Cases such as Siemendorf, Emerson, Dickinson, all recent decisions by the Fourth Department where the plaintiff's expert fails on the issue of causation or is speculative, conclusory, and or unqualified to render an opinion on causation. Here it's important to note that what Ms. Mason had ultimately diagnosed at the Cleveland Clinic was a very rare autoimmune disorder of VKH. We submitted a pediatric ophthalmology expert that says, based on the chronology of events, including Ms. Mason's failure to respond to treatment, there does come a time when she sees a retinal specialist in the Western New York area and has 6 visits with the retinal specialist under close watch over a period of 4 weeks, and there is no response to treatment. Our expert in pediatric ophthalmology, who's qualified to render an opinion, says based on the chronology of events, her failure to respond to the treatments by the retinal specialist, there is no possible connection between Dr. Cormier's single emergency department visit and the ultimate
Did either
injuries.
expert that you submitted, Ms. Zittle, opine to the effect that as of January 16, 2012, this condition cannot be remediated whatsoever? Did anyone take the position that nothing could have been done after January 16th, the ER visit afterwards? As I read it, just to answer my own question, but I want to give you a chance to disagree. I see nothing in your expert's opinion that say that nothing could be done after the ER visit to improve or better the outcome of this particular plaintiff or patient. Do I have that right anyways?
At page 1385 of the record, Dr. Markowitz's affirmation sets forth the entire chronology of events. And it's also important to note that Dr. Cormier did recommend as part of the discharge instructions, both
That's not the
verbally
question.
and in writing.
The question is there anything in the record that suggests that had she called and made the reference, that would have changed the outcome in any way?
Dr. Markowitz says that the lack of response to treatment by the ophthalmologist, Dr. Lee, the retinal specialist, and that chronology of events of seeing her pediatrician, then Dr. Atkinson, then Dr. Lee, because there was no response there, and the chronology of events, there is no possible causal connection or causal relationship between Dr. Cormier's proper and thorough evaluation and the injuries. That is what Dr. Markowitz says, that there's no possible way to link it. So I think that does say that there's nothing that could have been done by Dr. Cormier to change the outcome.
Let me ask it in a different way. I think this is the same question my colleagues have asked. Does the record reflect that the child's fate was set at the night she was received in the emergency department?
I think there is.
Not I think, but does the record reflect that the child's fate was set at that moment?
Dr. Markowitz does say, based on the chronology of events, that there was nothing that could have possibly been done. By saying there's no possible causal connection, that certainly implies that nothing could have been done to change the course of events.
But that's the plaintiff's point. What could have been done that night is the physician could have made the call and started the process then, as opposed to delegating that to mom, who the physician says was somewhat dismissive, had this body language, I wasn't even sure she was going to follow up. And your expert doesn't clarify, that's what we're asking, whether the child's fate was set at that moment. That nothing could have been done.
I think that's what Dr. Markowitz does say, based on how her course progressed over the following 6 weeks. Additionally,
Well, didn't
Dr. Cormier.
Didn't Dr. Markowitz also state in 1383 to 84, the alleged delay of 1 day that would have occurred if the patient had seen an ophthalmologist the next day, as directed, would not have had and did not have any significant impact on the outcome. So is that in the record he's saying that basically that's what answers these various questions that are being posed to you now?
Yes, Your Honor. That is correct. Dr. Markowitz does say that
What's
there's no.
about that, just to follow up to Justice Montour, is that what's about the significant impact language. What Justice Del Conte was asking, was the fate sealed? Not was it substantially sealed? Was the fate sealed? That is, I would have expected in this situation that the expert would have opined that as of that date, January, 16 of 2012, nothing after that could do to fix what we had on that date. So therefore, it's irremediable, is my word. So I didn't see that. And when you then change it to substantial or significant impact, that leaves an opening. It may not be the greatest argument at trial, but again, we're not supposed to grant your expert inferences or implications. We're supposed to grant the non-movement that way. And the other thing I wanted to ask you too is about did you cite the Hain versus Jameson in terms of how typically these issues with respect to causation and foreseeability are left to the fact finder? I mean, that's the most recent case on this issue, and I don't see you citing there recognizing that this is a very uphill argument when you focus on causation. Do you agree with that?
I think I did cite that case, and I also, in my reply brief, and I also did combat it with the string cite of cases where this court does decide medical malpractice cases on summary judgment on the issue of causation. So I do directly address that in my reply brief. In addition, the issue really is there anything Dr. Cormier could have done differently to affect the outcome? She examined, right.
We understand all that.
She examined Ms. Mason. She performed the full exam that she could have done in the ER at that time. She referred her to an ophthalmologist. She said, I think something more serious is going on here. You need to take her to an ophthalmologist.
Right, we understand.
Ms. Myler acknowledges that.
We understand.
I was told to go to an ophthalmologist. It was in the paperwork. She knows she was supposed to do that.
We understand all that. We have to look at all this very carefully. So thank you.
All right, thank you.
Good morning, Your Honors. It's our position that the defense attorneys and the defendant did not even meet the initial burden to shift the burden to us. Our position has been that Dr. Cormier had an obligation to ensure that this child was seen by an ophthalmologist, that she had an obligation to make a call and make the arrangements that day. And the rebuttal to that seems to be, well, it's the mother's fault that it didn't happen. That doesn't address the fact that their expert does not address what we're saying Dr. Cormier's obligation was, which was, excuse me, to make arrangements for this child to be seen by the appropriate medical specialist. In terms of the defense saying that there's a break in the causal connection, well, the fact that she has subsequent treatment doesn't make it a situation where there's a break in the causal connection. I mean, yes, she has subsequent treatment by other providers. We take the position that there was malpractice there as well. That's why they're defendants in this case. But that's no different than any other case where there's subsequent treatment. That doesn't rise to the level of breaking the causal connection.
Ms. Fahey, we have a case called Pagel versus Mullins and other cases that cite to it. It's not a med-mal case, but it stands for the proposition that when you move as a defendant, you're supposed to establish first, you were not negligent as a matter of law, and even if you were, then you go to causation. So here, as I understand the defendant's experts are like, we did nothing wrong, therefore we didn't cause anything. Don't you have to assume, when you just attack causation, as seems to be the argument here on appeal, don't you have to assume, just for the sake of argument, that there was some form of negligence, and even if that negligence occurred, this is how it didn't cause it? Is that the proper analysis?
Well, I do agree with you, Your Honor, that you have to assume that there was negligence here. I mean, we have an expert who says there was negligence here.
Only when you're addressing the causation issue solely. I mean, they moved on both, but on appeals, I read it, they're just going after causation. And I don't know how to judge causation without looking at what's the basis of the alleged negligence. But if all we have is, I did nothing wrong, that only means there's no compensable harm, irrespective of the cause. So that's what I'm struggling with this case. I'm not sure this is the greatest malpractice case. It's in terms of saying the doctor should have called that night after 8 o'clock or whatever, but putting that aside, that's sort of what I'm struggling with on this case is, can we decide this on causation? And I've got to take a look at that.
Okay. I do not believe, Your Honor, in my analysis of their expert's affidavit, that they have said enough in order to meet the causation aspect of it. That they have not established that the course would have been the same if the treatment had been rendered on the 16th, I guess, that the referral had been made and the appropriate treatment had been rendered. It's not enough to say that when she did finally get treatment 6 weeks later, she didn't respond well. Well, this is an autoimmune disease. Earlier treatment would have a different impact, would be our position.
This is
But-
a delayed diagnosis case, right? Which means the loss of chance concept for causation also applies.
Yes.
I think we have that. Thank you.
Okay, thank you.
585 through 586 is Coppola versus Tennyson Court.
Good morning. May it please the court, Megan Roll on behalf of the defendants. This action was commenced by an individual who did not have the proper authority to sue, as he was not the personal representative appointed by the surrogate's court, which is required pursuant to the estate's law. There's a long line of Fourth Department precedent that establishes that in circumstances such as this, the trial court must dismiss the complaint when faced with this motion.
Let's hold that thought for a second, Ms. Roll.
Sure.
If I understand your motion papers below, your motion was that because it was brought by the wrong person, it must be dismissed with prejudice. That's what you asked for. At least that's what I saw in the record.
That's what we asked
Are
for.
you still asking for that on appeal, and if so, on what basis?
I'm still asking for the case to be dismissed for several reasons with prejudice, including the fact that a personal representative was not properly appointed and commenced the case. The person who did commence the lawsuit did not have the authority to.
Let's just stick with that issue, not the other ones, for my benefit.
Sure.
On my question. So I wasn't clear in your brief. I'm not faulting. I just want to make sure that what you're suggesting, what you're arguing here, is that if we agree with your argument as to substitution, that is, that there was no ability to substitute here, that 1015 does not allow substitution, CPLR 1015 does not allow substitution in this situation, that your client is entitled to dismissal with prejudice and therefore no opportunity to do 205.
That's our position. I recognize that CPR 205 may provide an avenue for them to recommence.
Which would be without prejudice, right, Ms. Roll?
Which would be without prejudice. However, you don't get to 205. There should have been no argument regarding 205 because the case should have been dismissed at the outset, and then secondarily, if they wanted to recommence pursuant to 205, then we can talk about 205 and its applicability. Then we can argue if it was with prejudice or without prejudice. But at this point in time, I would submit respectfully that the case should have never gone beyond the analysis of whether or not there was a proper person who sued the case. It should have been dismissed right there, but it wasn't. And the argument that was made by plaintiff's counsel to the trial court was that they should overlook the authority issue because 205 is available to them. And you're skipping a step. That's not what this is all about. There's precedent that we must follow, and the precedent here is that this case should have been dismissed, and if they elected to proceed with the lawsuit later on, then 205 would have been analyzed.
Ms. Roll, in this case, we have 22 months between the date of death and the appointment of the representative. A fairly long time. Does the plaintiff have a remedy short of doing these logistics, this bringing in action where they have no standing? Is there a remedy that they had that they missed out on here?
Yeah, they could have sought personal representative appointment prior to when they did. You can do that immediately. Short of that, I'm not aware specifically, but I'm also not a plaintiff's attorney, so I'm not well versed in the steps that may be taken to step aside, I suppose, the surrogate's court. I think that perhaps 205 is a provision to allow for a remedy at a later date in a reflective standpoint. But again, our argument to the trial court was that you don't even get there because they didn't have the proper authority to commence the lawsuit in the first place, which I think is probably well received. I think just in summary with this point, plaintiff is still asking this court to sacrifice compliance with the law and the statutory requirements in exchange for efficiency. And it's simply not appropriate. And I think some may question here, what harm would it be to do that? And I would submit respectfully that it's not so much about where we are, but how you got there. And that precedent obviously is very important, and it would open the floodgates and create a slippery slope, perhaps negating the requirements under the EPTL.
I think we have that on camera.
Okay.
Could you comment on favorite limited? The case, the favorite limited, the case.
Yes, I would love to, Your Honor. I would respectfully submit that it shouldn't be considered. However, if the arguments are to be considered, it's distinguishable. The favorite case did not involve a personal representative. It did not involve the EPTL. There was not a deceased person, obviously. And then secondarily, that case involved an ongoing lawsuit which was properly commenced, which the court then used its discretion to substitute the parties. Here, the fatal flaw was that, according to the Court of Appeals, the fatal flaw is that there was no authority to commence the lawsuit in the first place, so the entirety of the lawsuit is a nullity. So therefore, there's no ability to have discretion by the trial court to add or substitute plaintiffs once they did receive the proper authority.
I think we have it.
Okay, thank you. Just briefly, if you would indulge me, I'd like to address the motion to dismiss the complaint and the substance because of the trial court having addressed that. I know that complaints are to be liberally construed. I know that the CPL requires that there to be particularization of the complaints. I would submit that this complaint doesn't have either. In fact, it only has the dates of admission to the adult home, bare allegations that the defendants were negligent and violated the public health law, and the injuries. Defendants, when looking at the complaint on its face, have really no information. They're left to surmise what actions or inactions during the 3.5-year admission were the cause of negligence, were the cause of the public health law violations. At a minimum, I would submit that the second and third causes of action regarding the public health law be dismissed for being insufficiently pled and also for failing to state a cause of action. I know that there's reliance upon the Cunningham case. I would submit that this is far different than the Cunningham case. There's certainly no facts alleged in this complaint that would even be similar to the Cunningham case. And in fact, the Cunningham case did not at all represent what plaintiff states it represented, that Public Health Law 28 applies to adult homes and assisted livings. As demonstrated in the motion to dismiss through the evidentiary documentation provided, Tennyson Court is an Article 46 facility. And Article 46 facility is very clearly, Article 46 very clearly states that these are not residential healthcare facilities, i.e. nursing homes, which are governed by Article 28. So I would submit that because it's an Article 46 facility, alleging that violations pursuant to Article 28 were made, that it just simply fails to state a cause of action because it's not that type of facility.
But it's not so much the designation of the facility, it's the services they provide. In Cunningham, that we went through all the various services, and many of these are not in the record here.
Correct. In Cunningham, it was alleged that there were healthcare services provided, including dementia care, certain specific personal care needs, healthcare. And here they were not. Nothing was alleged.
Thank you.
May I just address quickly the issue regarding defendant hands? Thank you. So I would just submit that because it's not an Article 40, or excuse me, because it's not Article 28 facility, there is no controlling person. Therefore, defendant hands was an improper party, and there is no claim stated against him, as well as Salem. Salem was just the landlord. The complaint does not articulate anything specifically as to Salem that would raise to the level of stating a claim. Thank you.
Good morning. May it please the court. Timothy Hudson on behalf of the plaintiff's respondents. The court should affirm the trial court below. With regard to the standing issue, the court did not abuse its discretion in granting the cross motion to substitute after the letters testamentary were issued by the Erie Surrogates Court to allow, we had the formal paper, the plaintiff to proceed in that matter. The favorite limited case divided the Court of Appeals on a standing or jurisdictional issue on the statutes, but makes it clear, I would submit to the court, that it is, that when you have an active action ongoing, it's in the discretion of the trial court under 3025 with 205 in the background to grant such relief and to do a substitution. And I would draw the court's attention to the fact that the letters testamentary were issued and part of the record below to the trial court and were considered by the trial court who issued and wrote a decision in this case.
I'm not sure, Mr. Hudson, that, and let me know if you disagree, that CPLR 1015 authorizes discretion to, for substitution where the person is deceased and unrepresented by the proper person on the EPTL at the time the actions commence. That's different than favorite limited. The entity was still extant at the time. But here it's pretty clear from the case law, as I understand it, that if the person's deceased at the time the actions commenced, I don't think the court has discretion like it does under 3025. Here, if you relied on 1015, that discretion I don't think exists if the person was dead at the time it was commenced.
I would submit that it does, Your Honor, both based on the case law and on the EPTL. I think that, the Carrick versus Central General Hospital, 51 New York 2nd, 242, it's a 1980 case. That
says dismiss and then allow you to do 205A.
It was. That was the procedure there. But it doesn't say that it's a nullity. And then I draw the court's attention to EPTL 11-3.2b for any action, for any injury, an action may be brought or continued by the personal representative. You're in the courthouse. I would say that the Carrick gets in the courthouse door, and now favorite limited says there's broad discretion here. The EPTL, that provision of the EPTL says once you're in the courthouse door, an action may be continued. Pending action, we have a cross motion, we have letters testamentary. While it's all pending before the trial court, I would submit that, especially given favorite limited and the statutory basis contemplated by the EPTL, it's within the trial court's discretion to not dismiss, but to allow such substitution.
We'll look at that.
And continuation of the lawsuit. With regard to the merits, the court below properly considered this court's decisions in Cunningham and Burkhart. There are allegations that there were health-related services provided in this action. That's right in the complaint. As Justice Nowak noted, that is kind of what drives the analysis here for the statutory causes of action. This is a pre-answer motion. There's no discovery. We're entitled to every favorable inference. That may be a fight or an argument for another day, but I would say that on a motion to dismiss, that we have more than satisfied our burden and that the trial court was correct in denying that portion of the motion. Thank you.
Thank you. 587, Catherine Gambini versus State of New York. What is this version? Morning. Just have to wait for Mr. Hines.
I am here. Good morning.
Oh, good morning. You're both here. Great. Go ahead.
Good morning, Your Honors. May it please the court, Philip Hines for the claimant appellant, Catherine Tambini. This is a case where the Court of Claims granted summary judgment progress defense. We asked that the this court reverse. December 14th of 2019, the claimant was Albion Correctional Facility.
Actually, we know all the facts. Why don't you go right to your argument?
Sure. So the argument is that the lower court only considered whether or not there was a storm in progress at the time of the fall. And as a result of her determination that there was, that the action was, summary judgment was granted. In our view, the question is not, was it snowing at the time, but were the actions of the state proper and reasonable as a result of there being a storm in progress?
Counselor, let me see if I can, Counselor, if I may interrupt you here, if I can frame this. Are you arguing that the defense doesn't apply here because your client was incarcerated, or are you arguing that the state owed your client some other independent duty which they didn't satisfy under these facts, or you raised a question of fact whether they satisfied that duty?
Yes, Your Honor. What we're arguing is that the state has a proprietary duty as a landowner, and that the storm in progress defense does not apply where they take the affirmative action of sending inmates out into unsafe areas and then be able to rely upon that defense wholeheartedly to say, well, although we sent them through these, unplowed, uncleared walkways, that whatever happened because it was snowing at the time, we're not responsible. And so sorry, I'm having an audio issue. I didn't know if I interrupted somebody. Sorry. So by their affirmative action of sending these inmates out, we're asking this court to clarify what the law is upon the state in these circumstances, as the Court of Claims has been largely reviewing these on a case-by-case basis and coming out with different answers each time.
So is it fair to say you're asking us to carve out an exception?
I don't know that there's necessarily an exception that has to be made, but I think a clarification to the lower courts need to be made. I mean, there are exceptions to the storm in progress doctrine that are already in place, and I think that those are adequate. There's a carve out for labor law 241(6) claims. There are carve outs where the property owner redirects water from onto a walkway and it freezes during a storm. Here, the issue is not that. The issue in particular is that here the state directed the inmates onto the frozen walkway rather than directing water onto the walkway. I think that this is we're not asking for a special exception. We're actually asking for there to be liability in situations where the state takes the affirmative action of putting people in potential places of danger and failing to act reasonably in those situations. There's
Mr. Hines,
Yes.
Can you hear me okay?
Yes.
Following up to along Justice Del Conte's lines, which you're asking about, if I understand it correctly, the storm in progress doctrine suspends the duty to exercise reasonable care to remedy the ice condition. So if I understand what you're asking us to do, you're saying, okay, reinstitute that duty when you're in a correctional facility. That sounds to me like you want us to create a special duty based on incarceration. And if we start doing that with the storm in progress suspension of a duty, where does that special duty end? That is, it seems to me there's that floodgates argument that if we do it for you here, that special duty is going to continue in other cases. Do you agree? And how do we avoid that if we want to go with you?
So I don't think a special duty is necessarily required here. I think that although certain courts have suggested that, and I cite to those in my papers, but I think that this is a matter of foreseeable risk to the inmates by the actions that are taken by the state. I think this is a consequence of prison officials' decisions to continue to run the facility as normal, despite there being a storm in progress. And then, as an aside, there is a big difference between what the claimant is asserting as how deep the snow was compared to the state's expert. And I mention that because the claimant claims that there was a foot of snow that they were trudging through, and the state's expert says there's about a half inch to an inch. But the storm in progress doctrine specifically relates to not requiring the property owner to take corrective measures while the storm is in progress if it would be futile. It wouldn't be futile in this particular situation, taking, the state's position that there was a half inch to an inch that fell over the course of an entire day, or to our position that even if that were the case, that it's not futile when you are directing people with zero ability to deviate to areas which are snow covered, whether it's an inch or a foot and a half or 2.5
I think we have it. I think we get that argument.
Okay. And so, I would just add, Your Honor, that, these are not, this is not a situation unique to prisons. Public schools in this state make this decision all the time. They have more people in their charge. They have much more real estate to cover. There's more schools than prisons, and yet the schools manage to not have children walking through a foot of snow to get in and out of the buildings. They manage to cease activities when the...
Okay, I think we understand that argument.
Okay. And then the other issue, Your Honor, I would just want to address would be that the state did not make their prima facie on their summary judgment motion based upon their experts' affirmation. Essentially, all their affirmation had to say was, from the meteorologist, was that that there was snow falling at the time of the accident, and which was never in dispute. And the lower court failed to consider or take judicial notice of the issues we raised in opposition, which were that the conditions that existed on the day or two prior to the event allowed for the pre-existing snow to have melted and then refrozen, and then the fresh snow fall on top of it during this relevant storm. And because the prior snow and ice, because the prior ice had not been removed, that what the claimant fell on was old ice. And there's plenty of case law which supports the fact that the failure to remove ice in between storms could. Okay. Thank you.
Thank you.
If there are no other questions, I'll rest on the papers.
Thank you. Go ahead. You have to unmute yourself first. There you go.
Sorry. May it please the court, Owen Demuth, on behalf of the respondent state. Your Honors, contrary to what you heard from counsel, what they're seeking, whether you call it a special duty or an exception to the Storm and Progress Doctrine, that's exactly what they're trying to carve out here. And that's not the law in New York, nor should it ever be. It's a novel argument because there is no dispute that there was a storm in progress. They realize they can't dispute that at the time of claimant's fall. They're trying to advance this novel argument that's never been established in New York. In fact, the same argument that claimant makes has already been rejected by the Court of Claims in the Appellate Division. What claimant's seeking to do is basically say the storm in progress defense should be wholly inapplicable at correctional facilities and unavailable solely because of the fact that because claimant was an incarcerated individual, her movement was restricted because of course of the fact of her incarceration. But New York has never condoned finding a heightened duty of care for some landowners as opposed to others. And that's, of course, what claimant is seeking here. What the Court of Appeals held nearly 50 years ago was that all property owners are held to a single duty of reasonable care. So by that same token, they should be afforded the same protections of that defense, which recognizes that it would be unreasonable not to suspend the duty of care while a storm continues to rage. And it's just a completely unworkable argument that claimant makes. If claimant were to succeed here, what that would do would be require state employees at correctional facilities to immediately make all walkways and roadways safe, even as snow and ice continue.
Do you think that's what he's saying, or is he saying that they had no choice of where they were going to walk, and that was part of the problem?
Well, yes, that is the hook of their argument. She had no choice. She had to go from this building to the other to get her shot, and she had to walk on the walkway. But they're also saying, so because the fact of her incarceration means that you could never argue that the duty is suspended, even though, as we know here, there was no doubt that snow was falling. I think the lack of choice, which of course is the hook for claimant's argument, regarding where a claimant could walk, I think that's relevant to proximate cause. For example, claimant could argue, I mean, she kind of already is, that but for the fact that I wasn't allowed to walk on the grass, I wouldn't have fallen. But that's proximate cause. We only get to that if the storm in progress doctrine doesn't apply, because that defense is solely concerned with duty. Does the duty exist or was it suspended? So it doesn't focus on choice. So the status of plaintiff or the status of claimant, which is what they're hanging their hat on here, is just irrelevant at this juncture. And I'm sorry, I don't remember which justice, because I didn't have a full screen at the time, I asked the question about the floodgates and where do we go if we find that there should be a carve out here. Well, it could lead to no end to problems for the state and pretty much eradicate the doctrine, at least as far as the state is concerned. And I'm thinking about a situation as just one example, maybe it's not a non-prison setting, but say a student on a SUNY campus falls while they're on their way to take a final exam, on their way to the lecture hall. Arguably, if the claimant were to succeed here, they could say, listen, I had no choice. This is my final exam. I'm paying tuition. I had to take this exam or I'd fail. Therefore, you can't ever say that there was a storm in progress, even if there was. So I think that's just another reason why this is just an untenable argument for them to make. So
Okay,
that's
we'll
really
look at that.
Okay, unless there are any questions, I would just ask that you affirm and rely on my brief.
Any questions? Thank you.
Thank you.
Keith Ballard versus 300 Eastern Boulevard, Canandaigua, LLC.
Good morning, Your Honor.
Wait just a minute. We're waiting for, there we go. Okay, go ahead.
Good morning to the court. May it please the court, Colin LaRoe on behalf of the plaintiff appellant Keith Ballard. We're here on plaintiff move for summary judgment. Obviously, the lower court denied based on finding questions of fact regarding the recalcitrant worker doctrine. At the lower court, it was found, it was conceded by the defendant that plaintiff met its burden, of a prima facie case. under 240 subsection 1. Thereafter, the court did find these questions of fact regarding whether or not Mr. Ballard could have been recalcitrant in refusing to use readily available safety devices. In short, the record is clear. Defendant has not met its burden of showing that plaintiff was recalcitrant. They relied solely on his employer, Mr. Kevin Hughes. He testified he was present the day before, or excuse me, he gave his deposition testimony that he was present the day before. And on that date, Mr. Ballard was wearing a harness. Therefore, he assumes it must have been present the next day. Furthermore, there is no showing by the defendant in this matter that there were any specific instructions that Mr. Ballard disregarded, that he refused to follow any orders, directions, instructions to use readily available safety devices.
Counsel,
Yes.
we have the Bianca-Netto case from the Court of Appeals from 2020 listing the four requirements with respect to sole proximate cause. Plaintiff had adequate safety devices. Plaintiff knew that they were available and were expected to use them. Plaintiff chose not to do so for no good reason, and then they would not have been injured but for that. Which of those elements hasn't been met by the employer's affidavit?
I think all of them, with respect to availability, and this court and I apologize whether it's shoot or shut, but it's Bookhaven. It's a 4-year-old case. This is the same case 4 years later, right? In that case, there were allegations by the employers who were present on site that said the day prior, the plaintiff was wearing a safety device, a harness, and that the day after, on the same construction site, he was not when he was injured. The court found that the allegations, the testimony of the two employers who were on site, that there were safety devices in a truck or nearby was insufficient.
But here he didn't go home in between.
That's correct.
They traveled to the site, so they were there. So
That's
where
correct.
could the safety device have gone?
Well, we don't know, but even a safety device on the site. So even if Mr. Hughes was correct that the day before he had a harness, we don't know where it was. Plaintiff, two witnesses stated they were never present. And in fact, I don't know that I made this apparent in the brief itself, but the record is clear. The OSHA investigation report revealed that the next week there was a walkthrough. The foreman at that point, I believe his name was Ryan Williams, asked how they should prevent themselves, deploy fall protection, and the OSHA investigator informed him of actions they could take. This Mr. Williams stated, "We typically do not use them when laying sheathing." And
But you're not suggesting that we turn and evaluate the evidence in this case and the contrary evidence. That's not the standard, right? We're supposed to just take the facts in the light most favorable to the defendant on your motion.
Correct. Even viewing the facts in the light most favorable and providing every inference to the defendant here, he can only state that he saw a harness the day before, and therefore it was either in a truck or a van or a trailer. And that's just with respect to the availability. Moving on to the other prongs of the knowledge of it, which again, your knowledge that he was expected to use these safety devices. Mr. Hughes and Mr. Hughes alone states the only instructions were you have to tie off. I told him you always have to tie off, right? The controlling case law is ignorance or ignorance of a specific instruction is not enough. It has to be a deliberate refusal. And this is not a specific instruction that he must wear a harness. There's no time, there's no place, there's no indication when he said it, where he said it. There's no testimony from the plaintiff that he was ever told you must wear a harness. And again, plaintiff and the two witnesses and Mr. Williams in this OSHA report indicate they didn't think they needed to. The lower court pointed towards plaintiff's admission that he thought at times they wore harnesses because it was more of an OSHA thing, which is irrelevant because it has to be a specific instruction to allow an employee's knowledge of OSHA to satisfy a employer or a property owner's burden to provide these safety devices would be contrary to the purpose of this law, 240 subsection 1, which is to protect workers, and it's to be liberally construed. So to even assuming Mr. Hughes says, and we believe him, that he said you always have to tie off, that is not sufficient to show that plaintiff purposely disregarded a specific instruction that he use a safety device.
Anything further?
Yeah, and then just briefly, lastly, the fourth prong here is
Oh,
that,
sorry, forgot about the fourth prong.
again, all four of these have to be met, right? So generic statements of availability are insufficient. Plaintiff's knowledge, there has to be some testimony, something besides the broad allegation that he knew, right? That's just an employer passing the buck essentially and saying he knew what OSHA was, and that's enough. He should have known better. And then lastly, with respect to whether or not he would have been injured had he used this device, the only testimony about the presence of harnesses other than Mr. Hughes, the owner of the company, was from the other witnesses who said they showed up the following Monday after the injury and that they were insufficient. They were frayed and that they had to go to Lowe's, in fact, to purchase new harnesses. So if we look at all of these facts together, there's nothing to suggest that any harnesses that may or may not have been on site could have prevented the injury. And then finally, I would just note that Mr. Hughes states on the day he allegedly saw Mr. Ballard wearing a harness, he cannot recall whether or not he was tied off, right? So if he were to see this and see a harness, there's no indication that there were lanyards that he was in fact tied off. So in short, plaintiff met his burden in the lower court, and the defendant has failed to prove a recalcitrant worker defense, and therefore our position is that the lower court erred and that summary judgment should be granted for Mr. Ballard.
Thank you. Go ahead.
Thank you, Your Honors. Mike Schmiel on behalf of the defendant respondent, 300 Eastern Boulevard, Canandaigua LLC. As an opening matter, I want to thank you for allowing me to participate online. And I'm just going to get right into the Bianconetto test that Justice Nowak brought up originally, because this is a fact-specific case, and that's what this is all about here.
Mr. Schmiel, generally speaking, those four factors, and I'm sure Mr. LaRue didn't mean it this way, but he said that you failed to prove the sole proximate cause defense. It's not so much that, it's whether or not you've raised a triable question of fact, and you're entitled to every favorable inference on our analysis. So essentially, you've heard plaintiffs argue, hey, we get to go to trial, there's a triable question of fact on this, give us every favorable inference. As I understand your brief, that's essentially the argument you're making here with respect to sole proximate cause.
Absolutely, Justice Curran. Yeah, we don't have to disprove everything right here. It's not our burden to establish it as a matter of law. It's merely to create a question of fact. And on each of the 4 points of the Bianconetto test, we do create a question of fact. Now, I understand that plaintiff might not believe Kevin Hughes, who's the general contractor in this case, but that in and of itself is obviously a jury question. Now, as far as the devices being available, the first prong of the test on here, well, there was abundant testimony from a variety of workers that they had used this equipment before. And I think it is very important to note that the plaintiff, Keith Ballard, is, for all intents and purposes, a foreman, a supervisor on this crew. In fact, what he does is he goes to the home base in Utica, he packs a truck, a van, that was provided to him by Hughes Construction with everything that he needs for this job. And then he and his crew, which include guys like Mark Sloan and Aaron Reinhardt, both of whom testified, they travel all the way over to Canandaigua and they spend the entire week with the equipment they have. In this case, he had the absolute authority, and in the past, he's been told many times to tie off by Kevin Hughes to pack whatever equipment he needed on this. However, Hughes did testify, whether plaintiff believes him or not, that he saw them using the equipment the day before and on other occasions on this particular site, as well as on other job sites in the past. And as Justice Nowak noted, they didn't go home or go anywhere between the day before and when this accident actually happened. The equipment was still on them. They chose not to use it, specifically Keith Ballard in this case. So the plaintiff always knew that this equipment was available. It was his choice to pack it or not pack it. The truth of the matter in this case, and I think this is the overall issue, is that the crew simply didn't like using any kind of tie-offs or harnesses on this particular type of job. The reality is this building that they were doing, they've built this type of building probably dozens of occasions before. It was repetitive and easy for them. All the equipment did was slow them up. This is testimony that we got from both Keith Ballard and from Aaron Reinhardt. They simply didn't like using the equipment, although they were told to use it. They knew it was available. They knew they were expected it to be used, because that's obviously what Keith Hughes told, or Kevin Hughes told them to do. There was no good reason not to use this on it. Again, the only reason it was ever proffered by any of the parties, including the plaintiff, was that it was simply slowing them down. This was too easy of a job for them, and they didn't like using it. They could have built this thing in their sleep.
Okay, you made that point very clear.
And would this have prevented an accident? The fourth prong on this? Well, at his deposition, Kevin Hughes did testify that he looked at the various pictures and the schematics, and he was able to see a number of parts where they could have tied off and been safe on this. That at least creates a question of fact with regard to the fourth prong. With all of those points made, I believe there's a question of fact. I think this has to go to a jury for further consideration on this. And unless there are any other questions, I'll stand on my papers.
Thank you. Thank you both.
Thank you so much.
All right, calling the case of 590, the matter of the arbitration between the Buffalo Teachers Federation and the Board of Education of Buffalo City School District. Counsel, I think we're all set.
Good afternoon. May it please the court, Jose Mandres of counsel to the office of Robert T. Riley on behalf of the Buffalo Teachers Federation. Your Honors, I would like to discuss why Arbitrator Gorman's arbitration award should have been vacated. We made 3 points in our brief, but for the purposes of oral argument, I will only address 2 of them unless the court wishes otherwise. First, Arbitrator Gorman's award was completely irrational because it rewrote the contract. Article 18, subsections A and B address different conduct, and they also have different procedures, which clearly makes them different and not subject to the same limitations. Arbitrator Gorman believed that marked deviation from good behavior encompasses all acts of misconduct, but Article 18 is not susceptible to this interpretation. At the outset, we see a clear distinction on its face. We also find it notable that the title of subsection B, assault and menace, sets it apart from subsection A. More importantly, perhaps, subsection C2 provides insight into what marked deviation from good behavior really means.
Counselor, you make a good argument that he made a mistake here in how he interpreted the 2 sections. But does that mean he exceeded his authority?
Well, Your Honor,
isn't that what the arbitrator was supposed to do here, was to look at this contract and make these calls?
Sure, Your Honor. When an arbitrator makes a decision or when they are interpreting a contract, if that interpretation is completely irrational, that is in excess of their power.
That's the standard, irrationality, not just being wrong. It has to be irrational.
I'm sorry, can you repeat your question?
That's your point. It has to be not just wrong, but irrational. And you say, in these circumstances, this is an irrational interpretation of those 2 provisions.
That is our point, that it is completely irrational. Subsection C2, for example, provides insight, right? It describes what can reasonably be read as nonviolent and general misbehavior, one that can be addressed through corrective action, through persuasion and instruction. It implies this intimate interaction between a misbehaved student and a teacher. That description has nothing to do and is entirely at odds with subsection B, which to some extent seeks to keep the student and the teacher apart from one another while the allegations of assault are heard. In fact, depending on the outcome of those allegations of assault, that separation between the teacher and the student can become permanent. It was therefore irrational to believe that marked deviation, given that description, could ever encompass cases of assault. It was also irrational to find that the limitation in subsection A, which excludes it from arbitration, also applied to subsection B. Your Honors, it is undeniable that that this case has broader implications because it involves a strong public policy regarding teacher safety, which brings me to my next point. The result of arbitrary Gorman's award creates an untenable conflict with the law and its policy concerns. When the teacher in this case was exposed to significant physical harm when the student that had just assaulted him was returned to his classroom. This not only violated the supplemental safety procedures in the collective bargaining agreement, it also violated the state's public policy, which seeks to ensure teacher and public employee safety. It was precisely these supplemental procedures that the union was seeking to enforce so that the allegations of assault could take their natural course, right? As a result of arbitrary Gorman's award, however, those safety procedures were left without an enforcement mechanism and at the discretion of the district now and forever. It's our belief that the implementation and the enforcement of these important safety procedures that are contractually and statutorily mandated can never, under any circumstance, depend on the whim of a school principal or much less on the irrational decision-making of an arbitrator. The stakes, in our opinion, Your Honors, are far too high. And finally, I'd like to address a point that the respondent made. Contrary to the district's argument that an arbitrator's powers are immune to some extent from public policy concerns, I'd like to draw the court's attention to people with developmental disabilities, 193 AD 1305. And in that case, the arbitrator was acting with absolute authority under the contract, and the court says as much. When the arbitrator issued the penalty, and the court there found that despite acting within his powers, the award itself, that is the result, was in conflict with the state's public policy. In that case, it dealt with sexual harassment. Here, it deals with teacher safety. Different facts, same underlying principles. So for the reasons that I have just described, Your Honors, fairness and the law demand a reversal of the lower court's decision.
Counsel, as you wrap up, quick curiosity on my part, I'm not sure that it's in the brief exactly, but under your theory, what the arbitrator should have done, correct me if I'm wrong, is to determine whether an assault had in fact occurred?
No, not at the procedural level.
But during the arbitration, wouldn't that have to be your position? To show that an assault had occurred, wouldn't the arbitrator have to decide that?
We don't believe so. The arbitrator, basically the question here was whether or not this can be arbitrated. So the issue of whether or not an assault took place would have come well after.
But assuming it could be arbitrated, would that be the issue?
It could be arbitrated had it gone further.
Okay, that's what I'm wondering.
Yes.
Even though the contract says it's within the sole authority of the principal to suspend pupils, you think the arbitrator has the power to decide that whether or not an assault occurred?
So the question here would never have been whether or not an assault occurred. The question
I thought you just said it was.
No. So the question would have been whether or not the principal followed the procedures, and the question of whether or not an assault took place would have come well after, when the matter was, the formal suspension was requested. Here, the principal actually had no discretion under the contract language. The principal's obligation under the contract was to suspend and to request a formal suspension. Okay.
Thank you.
If the court doesn't have any more questions, I will rely on my brief for my remaining points.
Thank you.
Thank you.
Good afternoon, may it please the court. This is Robert Quinn on behalf of the respondent, Buffalo Board of Education. Justice Curran, to address that last point, I think ultimately the arbitrator would have had to have been deciding the issue of student suspension. It goes beyond whether or not an assault occurred. It would have been whether or not student suspension should have occurred. And as is set forth throughout our brief, that is really not an arbitral matter. Public policy.
Counselor, if I could hold you up just for a moment there, isn't the real issue whether there should have been that interim suspension?
There was an interim suspension. There was a 5-day suspension that did occur. And that's why I argue that public policy, for all the talk about it, was followed here. The student was suspended after the incident. It was investigated, as was required under the CBA. The only issue that the petitioners are making is that they wanted an additional formal suspension that would have gone a formal hearing and suspension that would have gone beyond what was afforded. And that brings in another public policy that I think is taken into account by both our arguments and the CBA and the arbitrator Gorman's decision, which is that we take we take seriously the safety issue and the rights of teachers to safety and all that other stuff. But there is a countervailing, to some extent, but also competing public policy in this case, which is that the students have a right to attend school. There's case law, there's requirements, there's formal hearings. All of that is governed by a different body of case law. And what the public policy says is that is within the exclusive discretion, and it really can't be delegated of the principal and the Board of Education. And that's set forth specifically in the section of the contract of the CBA that the petitioners are trying to rely on, which states, and I'll quote, "The sole authority within a school to suspend pupils rests with the principal." So that could not be more clear. And to bring it back to your initial point, Justice Del Conte, the question is not necessarily whether or not arbitrator Gorman got it right. The question is whether or not it was rational. And if you read his actual opinion and award, he recognizes that there are competing arguments. And what he says ultimately is that the district's argument is more compelling. And I think that's the correct decision, because that is actually what the contract says. If you read the section, it makes clear, it could not be more clear, that marked deviation from good standards goes through the first 3 steps of the grievance procedure. That's what happened here. It was evaluated. So it was considered. They looked at the issue. They looked at the facts. They looked at what the appropriate suspension was. And ultimately, a determination was made. It's not that it was ignored or disregarded. This was considered, and it was considered in accordance with the CBA. But that's where it stopped. And that's where it stopped, likely because of the public policy, which states that suspension and student discipline is the exclusive sole responsibility of the district. And that's what happened here. So I think both under the standard and the court, I think, would recognize that both the trial courts and this appellate court's role in this is limited. It is not to substitute their own judgment. It is not to even say whether or not it was actually 100% right. It's whether or not it was rational. And here, clearly, based on the explicit terms of the CBA, it was rational. There's no other arguments. There's not an argument about a past practice. There's not an argument about anything specific. It's just the interpretation of the contract. And Justice Del Conte, you made the good point. That's exactly what the arbitrator was asked to do here. That's what he did. Petitioners disagree with it, but that's not the basis for an Article 75. So we think ultimately the petition was properly denied and that the court did affirm the award accordingly under Article 75(11). And I think that should be affirmed for all the reasons that we've made and were stated by the trial court.
Thank you very much.
Thank you all.
591 matter of Wayne Spence, and Justice Del Conte is recused on this matter.
Good afternoon, Your Honors. John Hitzius for appellants. Let me begin by explaining why Supreme Court erred in finding the arbitrator's award here contrary to public policy. Supreme Court conflates the arbitrator's award with enforcement of a rule that it had previously invalidated. But the arbitrator's award in and of itself upheld an employment determination, namely the termination of la framboise. If we look at the rule...
That was the responsibility of the arbitrator, right?
That's right. Per the CBA, the arbitrator is tasked with reviewing employment determinations. SUNY proposes, we want to terminate la framboise. She appeals it to an arbitrator. And so former 2.61 of the Department of Health's regulations says nothing whatsoever about employee discipline. It does direct hospitals to, in turn, direct their employees to get vaccinations. But what happens if somebody refuses? That's solely up to the employer. So there's no enforcement here. Now, I expect that La Framboise might argue that by SUNY's own actions, by way of the charges, this whole disciplinary proceeding can't be divorced from 2.61. But if that's the case, it simply means that SUNY was acting in reliance on 2.61 at the time, which makes perfect sense. At the time, that rule was in effect. SUNY wanted to comply with it. Is there a policy out there that says that if a court later invalidates this rule, after an employee has already committed a violation, that the disciplinary determination has to just stop in its tracks? The arbitrator, even after a hearing, has to just dismiss everything. We argue that there is no such public policy. Supreme Court divines a public policy from its own prior order in medical professionals, which, as this court's aware, had declared 2.61 invalid. That can't be right. And the reason it can't be right is because medical professionals was a facial challenge to 2.61. The plaintiffs in that case did not sue any employers. They didn't ask to enjoin or vacate an employment determination. Supreme Court simply had no occasion to ask, what are the ramifications? Supreme Court obviously believes, by virtue of the decision we're appealing, that medical professionals means employers couldn't continue with discipline. But to reach that conclusion, you have to take a logical leap. And that logical leap would require extended legal analysis, which has no place in an Article 75 proceeding. But whatever import medical professionals has, at the end of the day, this reflects the ruling of a single trial court judge, a ruling that's also conflicted with rulings that came before. Coordinate courts had addressed the exact same arguments and found 2.61 valid. And in the wake of medical professionals, we know that the Third Department in Parks and federal district courts in numerous cases, in cases involving employment disputes over refusals to receive vaccinations, they've said, we take note of medical professionals, but we're not going to follow it. So the law is unsettled. It remains unsettled. In light of the repeal, it's not likely to get settled anytime soon. Now, certainly, a trial judge has the prerogative and sometimes the obligation to weigh into this legal debate, particularly if that issue is brought before that judge.
Let me ask you, but all we need to know here is, was the award totally irrational?
On the irrationality point, absolutely not. Irrationality is about...
I'm saying that's all we need to decide here. You don't have to go into the legislative, what the legislature did, et cetera. This is just has to do with, like you explained, the employer taking action with regard to the employment of the employee, and was what the arbitrator did totally irrational?
Not at all. Your Honor, irrationality, as this court is aware, is about the facts. Here the facts are quite straightforward. SUNY directed La Framboise to receive a vaccine. She was aware of the directive. She refused. The arbitrator found that she did what we accused her of doing. The arbitrator also found that termination was warranted. because SUNY told her to get vaccinated, said you need to do this to keep your job.
Those are the two issues before the arbitrator.
Those were the two issues before the arbitrator.
That's what I'm trying to say.
No, I understand, but Supreme Court had found that it was irrational. I'm just explaining why Supreme Court's wrong.
And didn't the arbitrator reference medical professionals too?
The arbitrator, so Supreme Court says that the arbitrator irrationally ignored medical professionals.
Right,
but if you look at page 33, the arbitrator says this is beyond my jurisdiction. The previous case that you had in Article 75, they were talking about the CBA. Here, if you look at the CBA, it's eminently rational to say my jurisdiction is limited to the facts.
I think that's what I was getting at. So I think we have that argument. Do you have anything further?
One question on the public policy argument. I mean, an arbitrator could theoretically, I'm not suggesting it's necessarily this case, although I know that's the alternative argument, that an arbitrator could give an award that's contrary to New York public policy. But the public policy that we should be looking at on that argument isn't something general like separation of powers. You're suggesting the public policy would have to be something like a public policy that would bar a hospital like SUNY Upstate from voluntarily complying with a regulation when one judge says that regulation should be invalidated. That would have to be the public policy for it to even apply here.
That's right, Your Honor. If I could give some meat to that analysis, assume that the legislature had passed a law like a healthcare workers' Bill of Rights that allows them to refuse whatever vaccination they want and keep their job. If an arbitrator says, I'm upholding your termination for refusing that vaccination, the award creates a direct conflict with the statute. And when we're talking about public policy, we are talking about the award itself. So in cases, for instance, Laframboise cites a CSEA case where a reinstatement created a direct conflict with a regulation. Reinstatement wasn't permitted under that regulation. It's not simply that a court disagrees with the reasoning, particularly where that reasoning, going one way or another, the courts themselves have reached different conclusions. And so we're far short of what it takes here. Just as a final point, I want to highlight that this doesn't leave employees like Laframboise without a remedy. At this litigation, the issue has become, did SUNY have the legal authority to terminate her? But if Laframboise genuinely believed that at the time of the arbitration, she could have gone to court and asked for the disciplinary proceeding to be enjoined on the basis that it rested on a legal fallacy. Imagine medical professionals, but they sued a hospital, something like that. She did not. She did what a lot of employees do, which is appeal to the arbitrator's sense of equity. She argues, I refused the vaccine, but I had been working for 3 months. The sky didn't fall. What's the big deal?
I think we understand that argument.
Fair enough, Your Honor. Thank you.
Good afternoon. May it please the court. Edward Green, Jr. for the respondents, Spence and Laframboise. As was discussed previously, there are two bases upon which the court below vacated the award. One was on public policy, and the other was on total irrationality. And those can be separate and distinct bases, one or the other. Here, they're somewhat interrelated, intertwined, but nonetheless, there were two bases upon which the court found this case, or found the award to be, found it necessary to vacate the award. Well, I think it's significant to look at the Court of Appeals decision in matter of the Buffalo PBA, which is 4 New York 3rd, and the quoted section here is at 662. The public policy considerations embodied in statute or decisional law, or when the public policy considerations embodied in statute or decisional law prohibit, in an absolute sense, particular matters from being decided or certain relief being granted by an arbitrator, then the case, then the award is in violation of the public policy.
Are you saying it's a violation of public policy because the court was aware of the medical professional's decision and disregarded it?
Because the court was aware of it.
The arbitrator was aware?
Sorry, because the arbitrator was aware of it, and the order expressly prohibited the enforcement or the implementation
But that wasn't a
of the
responsibility
vaccine mandate.
That wasn't, go ahead, I'm sorry.
And the charges, if you review the charges in the record, each and every charge, specification in the charge, cited the Department of Health vaccine mandate as the source of the directive to be vaccinated. And when that regulation itself, when the vaccine mandate was essentially vacated by Onondaga Supreme Court, that basis for each of the specifications in the charges was no longer present. And
Mr. Green, let me interrupt you, because that brings us back, I think, to what I hear from Justice Noack, Justice Montour. The way I understand the question is, if that is your argument, then the arbitrator, what if there's conflicting decisions, as there apparently were here, among Supreme Court justices? That happens. It happens between appellate.
It does, but this is a decision in Onondaga County issued in the midst of the continuing ongoing disputes as to the enforceability and appropriateness of this regulation.
What you're saying
But it's a decision issued in that county that prohibits.
Let me interrupt you again. I'm sorry to do it again, but
yeah, sure.
I'm not sure you're getting to the ultimate question here. So you're saying it's Onondaga County. So are you saying, is your point that because it's the locality where this occurred, that decision by this particular court was controlling? Doesn't that have to be your argument?
Yes, but not necessarily or not completely, because in this case, what we had, there were a number of previous decisions on a variety of other types of challenges to the regulation that were denied in federal courts based on discrimination, reasonable accommodation, religious exemptions. Here, this was a facial challenge to the validity of the regulation. The other cases were denied or dismissed on various bases. In this case, the court decided and ordered that the regulation not be enforced. And on the date upon which the arbitrator in this case issued the award, despite pleas from the representatives of the respondents in this case, to at least to put the case on hold, to reserve decision until some of these issues were worked out, until this court had the opportunity to hear the case on appeal. The arbitrator disregarded that, and during the pendency of a valid court order prohibiting enforcement or implementation of the vaccine mandate, authorized a state agency entity, SUNY Upstate, to terminate this employee's employment, and they did.
We understand. Do you have anything further?
Just that, I want to clarify one point about the nature of our collective bargaining agreement. In this case, the collective bargaining agreement allows an employer to propose a penalty. That penalty cannot be implemented until and unless an arbitrator decides it. There are contracts that allow an employee to be terminated immediately and then allow a review and potentially reinstatement. In this case, Ms. Laframboise was not terminated.
I don't recall that being part of the argument below.
It was discussed at oral argument below that in our Article 33.5 is in the record as the article that the disciplinary governs the disciplinary process. But I'm just trying to make clear to the court that discipline was not imposed prior to medical professionals. discipline was proposed literally the day after the decision was issued in medical professionals, and with the arbitrator having full knowledge of that decision.
I understand that. Thank you.
Thank you, Your Honor.
592, Maria Fernandez S.D.'s versus Canisius College.
Good afternoon, Your Honors. Jennifer Morgan-Levy for the appellants. This case provides a much-needed opportunity for courts in the lower courts in the Fourth Department to gain clarity regarding the scope of types of claims that can be made by faculty members against their employers when those faculty members have a clear contract that is term limited. The lower court made the determination largely based on its interpretation of the matters of Hansbrough. I, as you know, have argued in my brief that that interpretation was inaccurate for several reasons. One is that there is not a requirement that every single claim that a faculty member wants to bring against their employer be brought through an Article 78. And I think that there is some confusion amongst the courts in New York State about this issue. And one of the reasons is that the cases range from student discipline cases to untenured faculty cases to tenured faculty cases to faculty discipline issues. And the nuances of the facts for each of those claims really make the determination regarding whether or not an Article 78 is the only procedure that can be used to challenge those determinations.
Counselor, you don't disagree that administrative decisions must be presented in Article 78, correct?
I agree that administrative decisions should go through an Article 78 unless the determinations are things that are in a contract with a faculty member. So if I have a contract with my employer or a contractor for my home doing home construction, and we have an agreement about how we're going to resolve disputes when they come up, and that is part of the contract, a failure to fulfill the obligations under that agreement.
Because your point, I think, is they didn't make an administrative decision here.
Yes, my point is that's what
your point. If you would have otherwise conceded it, but the counterpoint is deciding which faculty to keep and which faculty to let go is purely administrative. It's purely an educational programming decision that has to be done by the university.
So I believe that in the handbook, in the Canisius Faculty Handbook, which expressly states that it is part of the contract for all full-time faculty members at Canisius, it provides opportunities, clear guidance for how those types of decisions could be made. And there are various different options. There's the faculty Committee on Faculty Status, and in several different chapters. And so my perspective is that those are if you're going to make a decision, it has to be made through the procedures that they have promised their faculty they will use when making those decisions.
Thank you.
I also think there's some really significant factual distinctions between matter of Hansbrough and this circumstance. In matters of Hansbrough, the faculty members brought their claim through a hybrid Article 78 and breach of contract. They made that decision. They opted in to the Article 78 proceeding. And I think that New York courts have been clear that you can bring a breach of contract claim as a faculty member against your institution.
Anything further?
Yes. Let me just one. I also wanted to touch on the issue of the ambiguities in the contract. So if we are to agree that there is a contract and that a breach of contract would be an appropriate claim to bring for these faculty members to challenge their former employer's termination, then the court should have taken a fair look at the various different interpretations that could be made by looking at the four corners of the contract. In the brief, I spelled this out quite fully. I don't know if you have any questions or concerns about that. Okay. And then the last, well, one more point that I'd like to make regarding the issues of fact that are still pending and would make this this decision not suitable for summary judgment is particularly about the financial exigency. So while certainly the college was going through a financial difficulty at that time, as the amicus brief articulated, there is a very specific interpretation of the term financial exigency that is used by colleges and universities. And in this circumstance, I do not believe that Canisius met that definition. One of the reasons is certainly because they chose to not declare a financial exigency. They specifically put information out to the community that contradicted the idea that they had a financial exigency. And because that financial exigency would need to be demonstrably bona fide in order for it to, according to respondents' argument, in order for them to be able to terminate faculty members, then I can't find that they met that demonstrable part of the definition, because they, if anything, hid the fact if it did exist, it was hidden from view from the faculty members.
Thank you.
And your response to their claim that, well, this had to be done in order to preserve the students going forward and so that we wouldn't lose the admissions that we had already had. So, well, that's all well and good, but it's still an issue of fact.
It's still an issue of fact, absolutely. And I think that, again, there are procedures that they could have used that they had established that could have allowed the faculty members to engage in that conversation, which is part of their role in the shared governance model that our colleges and universities operate under. And they chose not to use those procedures.
I think we have your argument. Thank you.
Wonderful, thank you.
Good afternoon. May it please the court. Jennifer McLaughlin for Canisius College, now Canisius University, since the filing of this case. As you pointed out, Canisius University, and I know you're aware of the facts, was suffering in the wake of COVID-19, a massive budget deficit that was exacerbated by the pandemic. It was no secret that it was going on prior to it. Its board was taking over the reins of Canisius and telling its administration, you need to make certain cuts, $12 million of it. We worked with a faculty working budget group. It was accelerated during the summer of July of 2020 during the pandemic. Some of the processes and procedures that the appellants would have liked to have seen, because the trade group, I'll call it AAUP, has these recommendations for them, we evaluated and determined we didn't have the time and luxury to go through them. The AAUP submitted an amicus brief here. They talk about their exacting procedures, that with the luxury of time and the ability to have full faculty hearings and appeals and information to deal with at that time would have been preferable to the appellants, but it wasn't available given our situation at that time. So it did look to its handbook, which is clear that in a bona fide financial exigency situation, it can separate with tenured faculty members. It's simple as that. And in its handbook, it also reserves for its Board of Trustees the interpretation of what that means. And a $20 million deficit, which we've put in the record, our budget projections, our adopted budgets, it's not been refuted, and as the trial court said, it's been uncontroverted. So
if the plaintiffs claim here that there is no bona fide financial exigency, why can't they bring an Article 78 proceeding to challenge the termination and then a breach of contract claim to seek damages?
Well, I think
why do they have only the one choice?
Well, I think it's an article, as in matter of Hansbrough, that's exactly what was done there. They brought an Article 78 and a hybrid breach of contract. And the court said, since this is properly brought as an Article 78, you've asked us to evaluate if what the college did in that case, the College of St. Rose, was rational. And in that case, if it was irrational, we could reinstate them and order them back pay and give them all of those items. But since it determined that what in a rational situation, an irrational situation, you could order the back pay and also reinstatement. But in our case, these folks had asked for review of our process and procedures and whether we acted rational in that way. I don't think there's a separate claim for breach of contract. It's two bites of the apple. Again, they could have got the attendant relief in any Article 78 that they should have
I'm
brought.
sorry, but the breach of contract would have provided some damages, some money, which they couldn't have gotten in the Article 78. That's clear.
Well, they could have gotten reinstatement again in back pay. Attendant relief is available in an Article 78.
But the ins and outs, I mean, the point that they've made, though, is there was never a formal declaration of a financial exigency. Students weren't notified. I mean, there was financial pressures, but whether there was an actual bona fide exigency, that might be a question of fact. Your point is, it doesn't negate the fact the statute of limitations have run on the Article 78 proceeding.
The Article 78, yes, that's right. The statute of limitations had run on the Article 78 proceeding, so it was too late at that point.
Right.
However, financial exigency and the declaration of financial exigency comes from, again, the AUP recommended actions. That's what the AUP would like schools to do. And there are schools across the country that have adopted some or all of those regulations in their handbook or none. Our school only adopted the 1940 statement and reserved for the board its interpretation. And the faculty handbook is much like a collective bargaining agreement. The faculty could have insisted that certain opportunities be available to them in the case of financial exigency. And the then President Hurley mentions in his affidavit, he reached out to have that done years before and they rejected it. So again, the financial exigency declaration, again, is something that the AUP would have liked us to go out and say, we're having financial exigency, we're going to start this process that the AUP would recommend we do, but is not otherwise required by our handbook.
Thank you.
If there are no further questions, I'll rest on my brief.
Four things.